You do start with the introduction. How do you start?
Yes, Dave, start.
Yes, sir, with the introduction.
Yes, go ahead.
Dale Eilerman once said, "A willingness to trust and openly listen to alternative ideas and views is essential for collaboration to be successful." A very good afternoon to everyone present. I, Dev Tejnani, a research assistant of the Student Division of Legal Desire and a member of the ADR Department of Legal Desire, would like to welcome the honorable panelists for joining us today and gracing us with their presence on the second day of the 2 days virtual conference on the future of ADR in the pre and the post-pandemic era. I would like to sincerely thank Senior Advocate Aruneshwar Gupta, sir, for taking out time from their busy schedule and joining us today. Next, I would like to thank the entire Legal Desire team and the ADR department, and especially Mr. Anuj Kumar, sir, for making this possible today. Today's discussion is on a very important topic, as the 2019 novel coronavirus disease, COVID-19 pandemic, has resulted in a period of exceptional uncertainty as well as substantial market instability worldwide. As previous crises have shown, commercial pressures on parties can lead to an increase in the disputes and recourse to national courts and other forms of dispute resolution, including arbitration. With a quarter of the world's population living under lockdown conditions, parties, their advisors, and the judicial and arbitral bodies worldwide are now finding themselves in a rather unique situation. The wide ranging effects of the pandemic are not just creating exceptionally difficult commercial circumstances, but are having an impact on the normal operation of the bodies that are there to assist parties in adjudicating those disputes. Courts and arbitral institutions have been making makeshift changes in their operations in order to respond to the effects of the pandemic, in order to reduce risks to their employees and their users, so as to do their part in reducing the burden on the healthcare system. The inherent flexibility built into the rules of most arbitral institutions should now possibly allow parties to confront the challenges of the current environment with a little more ease than users of the national courts, particularly those courts in which e-filing is still in its infancy. However, parties do not always make the most of that flexibility, and many in the arbitration community will be forced to find creative solutions and new ways of working. Surmounting these challenges might hopefully lead to more efficient ways of working in the future. Our honorable panelists today will be dealing with these aspects and how ADR is possibly no longer an alternative to traversing the court system, but is rather the only sustainable method for speedy resolution of disputes. With this, I would like to end the brief note, and I would like to hereby introduce our first speaker for today, Senior Advocate Aruneshwar Gupta, sir. Senior Advocate Aruneshwar Gupta, sir, has actively practiced as an advocate in the Supreme Court of India since the year 1976 and has been an advocate on record and the additional Advocate General for the state of Rajasthan in the Supreme Court for about a period of 14 years. Sir has effectively represented clients in Singapore and the United States in matters relating to the power project and matters concerning injury claims. Sir has also drafted the Sports Act for the state of Rajasthan, UP, and Himachal Pradesh, which changed the entire course of the sports regime. And it is because of Sir that we now enjoy the Indian Premier League or the IPL. Sir is a specialist in strategic consultancy and is an expert in the field of arbitration, constitutional, contract, criminal, service, and general civil law. We are extremely delighted to have you today, sir. Today, Sir would be elucidating upon alternate dispute resolution and the fourth industrial revolution and globalization 4.0. With this, I would like to cordially invite Senior Advocate Aruneshwar Gupta, sir, to kindly share his insights with the audience. The floor is all yours, sir.
Good afternoon, everybody. I'm extremely happy that Legal Desire has initiated this process. And I think there's a need and a necessity of the time with online learning and this. Then I think this is a part of the Industrial Revolution 4.0 that everybody is now moving to an online system. Though it has been forced upon the entire globe by virtue of COVID. But otherwise also this was a necessity of time. And I think it is a must that we should all learn, particularly the new generation, to deal with these situations which may arise from time to time and continue to do it. It's very interesting to see legal desire, and I think legal desire would mean those who wants to have a deep desire to be legal. Basically, we are a service industry. Everybody who joins the legal service must have a deep desire, and the deep desire is basically for truth and justice. And let me tell you, this is the only profession in the world where you are paid to speak the truth or to search the truth and to do complete justice between the parties. You may be from one side or you may be from the other side. You may lose or you may win. But ultimate aim of every lawyer, every judge, and every person is that they must finally reach the truth. So let me start, because this DIG 4.0 is a very interesting word which I have incidentally coined, and particularly looking to the new generation, because this is the generation of you law students who are now and who will be there. We are in 2020, and I believe that everybody who becomes a lawyer now will at least have 50 years to go. So you are there till 2070. So what you must do is you have to look the world that it will exist, not today, because you'll take at least 5 years to really put your foot down dig your foot into the profession. And then another 10 years to have a feel of the whole game. And then for next 35, you start doing it. So what will be the world that you'll be facing around 2030, 2040, 2050, 2060? Now, if you're aware of that, you have to prepare yourself for that today. So let me make you very clear on this dimensions. And I think, large number of you must have seen a movie known as Interstellar. The Interstellar already talks of fifth dimension. And people hear about fifth dimension, but people really don't know what exactly dimensions are. And I'm making this, this fact clear because you will understand how the world is growing, how it is moving on. So once you know the direction of the world, of the globe, so there are multiple layers of growth. So one is the dimension. When I talk about dimension, it is a dimension of the human being also. When we talk of industrial revolution, it again 4.0. Then globalization is again 4.0. And incidentally, there's a very interesting book which has recently come, is the education revolution, the fourth education revolution. So everything is now moved to the fourth. But once we have moved from third to fourth, there'll always be going to fifth and sixth and seventh. So I hope by the people you really are on, you will be aware of what is fifth dimension and what is sixth dimension. So you will be really struggling with situations of globalization 4.0 and industrial revolution 5.0. So let us go with dimensions first. So I'm dealing with the first. Let us understand what is the first dimension. So the first dimension is basically a dot or a straight line. A straight line joins two dots. So it doesn't have it doesn't have a dimension. So that is what is called the first dimension. And then when you implement it comes to the individual, then an individual existing as a unit. Now that was when individual was existing as a unit, he was a nomad. He was without settlement. So we are talking of pre-civilization, pre-agriculture age. Now when you again push it further, the whole idea, it is the consciousness. It is like the waking stage at the morning. When you wake up, then you are just aware of your own self. But that is the first dimension in which you exist. And it was a time when prior to 1770, it was the entire world existed, because that is one thinking, that the entire world existed in the first dimension with a pre-agriculture stage. Then the agriculture set in. When the agriculture set in, the first thing was people became aware of an area. So you have a length and you have a breadth. So you have got area around you. So there are areas can be square, it can be rectangle, it can be a circle, it can be a triangle. So that is when you talk of mathematics or geometry. But in the civilization, it became settlement. People start settling. They had a civilization. They had family. Then they got tribes. Then was the clan colony. The concept of ownership of land began. This is where we say that the agriculture age came in. And I wish most of you must read Toffler. Alvin Toffler was first wave. He talks about this first wave, second wave, third wave, and now fourth wave. And this was the use of education and knowledge for survival. So And the initial stage, when you talk of the first dimension, there was no knowledge. The knowledge was there, but that movement of the knowledge to the next generation was not there. So second generation came in when the knowledge moved to other generation. So it was used for survival. So the tools came in. Then there were action, but at that, even that time, point of time, since the survival was a major issue, the action was charged with passion. It was a man-to-man combat using sword or knife. So it was one man fighting against another man and using one weapon. Now, this was the way of settling of a dispute at that point of time. So agriculture, when you talk of agriculture age, the way of settlement of a dispute was either duel, you use a sword or you use a knife. So this was pre-1770. And this is, if you look at the human being, so after the waking stage, what comes is the awareness of the existing of nature. So you just become aware of you. So that is the second dimension. When you start seeing people around you, that is the second dimension. So now then we move to the next slide. And that is when we talk of the third dimension and the fourth dimension. So third dimension is when we start having a cube or a volume, a prism or a ball. So this is expansion of territories beyond nation. Now this is where we can talk of say 1419, year 1300 or 1400, when companies were formed by Britain and East India Company Charter was created in 1499. So that was a time when the world started expanding basically because Europe, they moved faster from the agriculture age, and they were already into shipping and other things. At this point of time, I'm not dealing with the other side of a theory, which also thinks that India was at a very highly developed country at that point of time. But we'll deal with that in some other situation. So when expansion was there beyond territories, then acquisition of land comes in. Now this is very interesting, which every one of you as a lawyer or as a student must know, that how was the title of land passed? Because ultimately entire land belonged to what? It is earth. So nobody had a title to the lands. And the title of the land, if you go back to the Ram Rajya system, there were Ashwamedh Yags. So wherever the horse went, the person, the king became the owner of that land. Wherever nobody was able to challenge the acquisition. So wherever the horse was moving around, that was the way acquisition of land takes place. But when more civilized the modern world came in, the acquisition of land was by discovery or by wars. So the American discovery theory came in. So they say we discovered America, and the Britishers said, okay, since we have discovered America, therefore America belongs to us. So that was a discovery. And if you don't agree with it, then we fight wars. A classic example of fighting wars was basically the way British India took over, the Britishers took over India, and India became British India. And one of the classic example I can tell you was a treaty of 1871 between British India when they attacked Punjab. That was a time when Punjab was ruled by after Ranjit Singh. So Ranjit Singh ji was the king, and then when he died, his son became the king. And when British attacked Punjab, the Punjab consisted of the entire area, including Kashmir. So they said, okay, now we have fought war against you, and we spent a total amount of 1.5 crores. So either you compensate with 1.5 crores or the territory is ours. So Hari Singh ji's father, who was then the GOCNC of Kashmir, he gave that 75 lakhs for Kashmir, and that was given to him as a general officer commander in chief. And Punjab was taken over by Britain, and it became a part of the British India. Now this is about how the acquisition of land continued. Now today land dispute is a major dispute. So you must understand how the dispute, now the title is passing by virtue of sale. So we have come in a more civilized society rather than a society where it was just by the power of the will. Now when came with that, the third dimension was the first, second, and third industrial revolutions. Now when you talk of the first revolution and the second revolution and the third revolution, This is the technological development as it took place from one point to another point to another point to another point. What the Industrial Revolution actually brought about? Industrial Revolution is dated as 1770, and it brought about accuracy, precision, punctuality, exactitude, and mass production. But also with mass production came was mass destruction. So instead of fighting with swords and knives, the guns were produced. The guns, initially it was pistols, so they had a single shot, then they had 6 shots. James Bond had a 7-shot pistol, and then came the machine guns. Then came bombs. Now this again, I'm referring to this because this is one way of settling the disputes. So if I enter your territory, you don't want to give me your territory, or somebody attacks me on the territory, then the only way to settle the dispute was to fight a war. And in fact, if you look at the Second World War, all the allies, even in the First World War and the Second World War, ultimately the allies fought the war, and then they said to Germany that, look, this is the loss that has been incurred as a result of the war. So there was a Vienna Treaty earlier, and then there was after Second World War, there was another treaty, which put the debt on Germany for incurring of loss. Now, this is one way of settling the dispute, which is internationally resolved. Now, there are no courts, but they settle it by treaties. So after that, so 1770, you find the third dimension coming in, where the nations were there, the territories were there, and the awareness of time and space is there. Now, after 2015, I'm putting that date because a lot of things have shifted after 2015, and that is a date when in the conference which is held at the World Economic Forum, the president of the World Economic Forum said that we are in the 4th Industrial Revolution. So with that came the 4th dimension, where people awareness of belief in a metaphysics. When I talk about metaphysics here, I'm talking it beyond physicality. Then life beyond mere physicality, quantum existence, internet. Internet hit the world around, say, 1990, and it became more prevalent in India after 2000. So internet came in, the web came in, space travel came in, borderless, genderless, classless society came in. Now, this is the world we are existing right now. So there was search of soulmates, intuitivism. So everything became 24/7 open, right? Right now, and this is, the COVID has pushed the world into the 4th dimension choicelessly. Now, open work culture. You see that now you must understand the distinction between 3rd dimension and the 4th dimension is that when in the 3rd dimension, when industrialization was at the peak, everybody has to have, if there was a single shift, you have to reach your office at 9 o'clock, like I was doing it from 9 o'clock till 9 o'clock. Otherwise, 9 o'clock to 7 o'clock. So there was a whole way of industries running away where there was a, beginning by virtue of a siren at 9 o'clock or 10 o'clock, whenever the shift starts, everybody is rushed to one place. And from their place, then everybody closes at 6 o'clock. So you leave out. Now this thing has gone. Today we have come into an open work culture. Today, all my juniors and all my staff and every one of you, we are all working from home. So working from home, and there's no time schedules. So the entire concept of time and space is broken down. Now there's a very, very important issue, because these issues will lead to different nature of conflicts. They will lead to different nature of disputes. And when there are disputes and conflict, they will lead to a different way of resolution of disputes. So what we got is TVs, we got mobile. Now TV, if you see today Netflix or the other channels, you can see a movie at your choice, which was never there. Otherwise you used to go to a PVR or to a cinema theater to watch movie during a particular period. So the time and space concept has gone. So you have got mobiles and internets, you have Netflix, then signs and symbols. Now this is what has started 1955, and now we are into the awareness of a spirituality. Now this is from awareness of a time and space we are giving. Now you see people are not talking more about health. everybody has suddenly become a doctor. Suddenly everybody has become a person who wants to tell you about good things in life. So this is a certain awareness of spirituality. But so we are in the fourth dimension. Now, if you're going back to the movie Interstellar, if you see that, they talk of fifth dimension. So there is an emotionality in the spirituality. So people are evolving to become better human beings. But on the other side, you see the two very clear thoughts processes. On one way, we have got Steven Pinker, who says, everything is going to be good. And I believe in that phenomena. That world is ultimately going to be more civil. People are better. Civil people will be able to manage themselves and take care of things by taking care of aberrations in the society. So there's an aberration of a society. So there's another class of people who think that everything that is going around is bad. It is horrible. Now that is what they talk of, what is called as the VUCA world, VUCA. The V is volatile, U is uncertain, C is complex, and A is ambiguous. So one group of people, they talk that the world that we are existing is a VUCA world. But I talk of a world which according to me is more of a harmonious world. It is a better situation that we are coming into. And so now we move to the next, what is industrial revolutions. The industrial revolution, if you see, we have seen the industrial revolution. Go to the next slide. Next slide. Okay, so we come to the next, the earlier one, the industrial revolutions. Okay, so the first industrial, I'm just repeating so far, so you become clear what were the three revolutions. So the first industrial revolution was steam in 1770. Now from this, as a result of the steam, what came was the engines, turbines. So that changed the entire, and that led to the second industrial revolution, that was electricity. So steam was the first industrial revolution which changed the existing world in 1770. Now all this what I'm telling you is to understand it, that this is what was existing, and as we move forward, so we are going to move forward. So from 1870 we had the electricity coming in, 1955 we had the third industrial revolution which had electronics, and 2015 we get the fourth industrial revolution when you're talking of blockchains, the artificial intelligence, robotics, and cryptocurrencies. Now these, there's a one very important thing that you must understand, that electricity doesn't exist without steam, though we have got solar electricity panels, but again the solar panels are made again out of electricity. So it's a cyclic situation. But electricity was built up on steam. The entire electronics is working on electricity. So if you don't have electricity, your electronics will not work. Even for recharging your batteries, you need electricity. Similarly, the fourth industrial revolution is built on the third industrial revolution. So you can't have blockchains unless you have the programs coming up. So you have algorithms working on, so you've got Facebooks and you've got all these things which are working on the internet are working because of the awareness of how to use the electronics or the internet for the benefit of the society. So the next is then robotics, the same, artificial intelligence is coming into play, because then that will be a very serious issue on robotics. So let me tell you a very interesting fact which I just talking to somebody only yesterday, and he says that it is possible today for anybody to create anybody's robo on the net. So you may have somebody of your own as a robo sitting in America, having the same email number, having the same mobile number, having everything in a digital format and working for you. Now that may be disastrous also, but that may be beneficial also. But that is going to happen. So after the fourth industrial revolution, and I will be very concerned, and you will see what comes into the fifth industrial revolution. And with each industrial revolution, there is to be a different, there are impacts which happen because of this. Okay, let's go to the next slide. Now, the importance is we must understand is what is the impact of industrial revolution. So impact of an industrial revolution, every industrial revolution has changed the means of production. So in first industrial revolution where it was land, so if you see originally in the first industrial revolution, you will have a lot of land disputes. When India became independent, one of the major issues was sealing and zamindari. So that were all relating to land. But then the industries developed. So when industries developed, the major issues were relating to industries. So you have labor issues, you have got service law, you have got wages, you have got pensions, and everything relating to industries. Then education. Now the education has changed. Education is changing. So today, when you have got online education, there may be problems of large number of students saying that did not get the connection. So there may be suits coming up and disputes coming up on that issues. The nature of service is changing. Till March, we were rushing to the court at every 9:30 every morning. And in last 6 months, we are all arguing all our matters online. So it changes the whole way of doing things. So in the fourth industrial revolution, the way of giving services has changed. So you may be sitting as a single law. Everybody will now, maybe the large law firms will have very different situation. And there will be more demands of maybe solo lawyers or middle-sized law firms. Then changes the way people do their business. So travel is a major issue. Now travel has stopped suddenly. So you will see people getting affected. The airline industry is getting affected. The shipping industry is getting affected. People don't want to travel. And if they want to travel, they don't want to use public transports. So there will be a very serious issue because of this fourth industrial revolution that is setting in. That changes institutions, education, family, politics, everything will change. Now that is the real issue when we come down to the last one. What does it do? It challenges law. So if you are as a law, you'll see law framers have a lot of difficulty how to deal with this new situation because ultimately people don't know what is the situation that is coming up. So you have like till today, the whole cryptocurrency issue started in 2008, but even today, regulating of cryptocurrency is becoming a major issue. So earlier, the RBI has banned it. Now the Supreme Court has said that you can't ban it. And therefore, the government is still struggling what sort of a law should be there to deal with cryptocurrencies. Similarly, there will be issues how to deal with robotics. So it challenges law, it challenges judges, and it challenges lawyers. Now, you as lawyers, now this is my advice to you, the young generation of this country, that if you are open, one of the major things as a lawyer is that you must know how to keep your mind open. And you must always be updated with what is going around the world in the latest technologies. Because that is where the disputes are going to come. And that is where the dispute resolution is going to come. So when we talk of lawyers, so judges and law, the law arbitration is basically a procedural law. The judges may not be there, but as a lawyer, you can be a very good arbitrator lawyer as we go forward. Okay, let's go to next. Let's rush through this globalization 4.0. So prior to, again, this is the last part of it. So you can understand what DIC 4.0 is. And we must, everybody talks of globalization, but people really don't know what is globalization. So I thought, let me tell you. So prior to 1000, year 1, I'm talking year 1000. Basically, there was trading. So there was Silk Route. People used to come to India through what we call the Silk Route. And people used to come and move around for education because at that point of time, the countries were already evolving. So people were not moving out. But then what happened in year 1000 is very peculiar when, Ghaznavi attacked India. So what he did was he carried people with him. So carrying out people from one place to another, and there were millions of people they moved around from India. So that was basically, according to my understanding, is in the year 1000, we had globalization 1.0 when people moved out. And around, 1400 or maybe 1300 when England, France, Portuguese, Dutch people So the ships, they started moving out. People moved out and they went to other countries. They brought in slaves from other countries and they used them as slaves. So there were people who were moving out. That was globalization 1.0. After the industrial production, which started in 1770, what really started moving was the goods. Now, if you talk it with reference to India, so 1757 was the first Plassey. And 1770 after Plassey, basically the goods, the raw material from India started moving out to England. And then we have got the entire industrial revolution coming up in England because of one of the major contributors was India, because a lot of gold and a lot of raw material from India was moved out. From 1770, as we continued the industrial revolution, then we come down to the technologies. So 1990, we have technology coming up. So this is where we set up of internet was there. And slowly, if you see the graph, India, the large companies like Infosys, and they were exporting, they became big because of transfer of technologies, because they exported people out who were well literate in technology. So that was globalization 4.0, 3.0. And then we have got now services. So you can be staying at home and providing services like we can do now, like what I'm doing right now. Is I'm telling you and talking to you as a services, we are talking of legal services, which can be imparted from home. And this is the new way of doing the entire services. Medical will change, education will change. So all these services have been moving out. So we can resolve a dispute in India, a dispute existing in say Africa. And I can tell you a very interesting issue when I did the first arbitration I did a major arbitration in Singapore. And then we won, we got a decree of about $2.82 million. And then I was sent by a client, told me to go to USA. That is very interesting to see that this case was basically relating to a power project in Andhra Pradesh. The client was from Singapore. I was from Delhi, and the matter was in New York. Now this was, this whole services, but now these all, I don't have to move out today. Today I can do the same thing by sitting here. So this is how these services will change, and that is what they're changing. So this is, now let's go to the next step. What happens? So like the impact of globalization, like the impact of industrial revolution. Let us understand what is the impact of globalization. So the impact of globalization is basically unbundling. So you must understand of this unbundling, that the larger groups are breaking down. And there's a book by Schumacher called The Small is Beautiful, which was written long back in 1960s. And I think that is one book which will now be more effective, and everybody should read it, because it becomes sweeter now. So governments unbundled. So Brexit is there. Finance is unbundling. The banks are now having difficulty with cryptocurrency, parallelly developing it. The businesses, as I said, small is beautiful. So small law firm, the large law firms will have to unbundle. So they may be small law firms, because the same services can be given by, solo lawyers or small law firms. So the whole idea of unbundling is taking place. And this is where we come down to the ADR, the alternate dispute resolution. So alternate dispute resolution is a part of unbundling of the legal industry. So the strict sense, ultimately the only issue with courts have got a support of the governments. They are part of a constitutional structure. But since their burden is more, and particularly the issue of specialization will come in. You see, if you are a lawyer who knows robotics, or you are a lawyer who knows cryptocurrencies, then you will be requested to be on the panel of a litigation in an alternate dispute resolution for cryptocurrencies. So this is the whole idea of the alternate dispute resolution, is because now we can have experts. So if you have got a person dealing with construction contracts, like the person who has done a major constructions, engineers. Now they are required more. So the issue is that you have a judge sitting there and you also have an engineer sitting there. So in all arbitrations, relating to construction, you have to have an engineer. Similarly, there are a number of matrimonial disputes. So you may have good social workers and other people's who have been working in the social groups to work as a special panelist for the alternate dispute resolution when it comes to it. Okay, so next we go, what is the impact basically is the nature of business changes. Let's go to the next slide. So nature of business changes. So now this is what we understand right now. So we come down to the existing situation. So there are commercial transactions. So trading is a commercial transaction. Now I'm getting into the nature of conflicts. So when you talk of conflicts, you must understand the nature of business. So they have got trading. So you have got contracts. There's the real estate contracts, the manufacturing contracts, the construction contracts. Then you have family, you've got succession disputes, and you've got property issues. Then government, you've got services, you've got infrastructure, you've got taxes, you've got contract. Now, taxes may never go for alternate dispute resolution because there's a lot of government is involved and nobody will concede to a situation. Then environment, mining versus forest, production, forest versus production. Now, this is where there is a lot of balance has to take place in the environment. And finally, we have got blockchains and artificial intelligence. And right now, the litigation, because this itself is maturing up, so we don't know what sort of a litigation will come up in blockchains and what sort of will come in artificial intelligence. Now, one of the major mantras, which I always say that this is what, if you're the lawyer, if you want to become a really good lawyer, is that if you want to help your clients, you must know how your client does his business. So if your client is in trading industry, you must know how the trading takes place. If he is doing construction, you must know construction contracts. So if you don't know construction, you see, you have to exactly understand the construction. We did a major arbitration on construction of an airport, where it was specified that the depth, at a particular depth, the road roller of say 10 tons will move 20 times. And one of the major disputes was that the contractor had done it only 6 times. Now, what are the implications of all this? Whether it will affect the entire runway will become useless, or what will affect, what damages it can cause. Now, these are all issues which will come as a lawyer, which you will have to deal with. So to be a professional lawyer and a good lawyer, what you really know is to know how your client is doing his business. So you have to go into details of knowing everything about it. Trading, services, infrastructure, contracts, forest, mining, you need to know everything about everything. Okay, so then we go to historicity. I think I can skip this up. This was only to tell you in our mythology. Hindu mythology, the first dispute was between one of the Saptrishis, who was Kashyap and Dipi, and then which resulted in the creation of Adityas and Asurs. So that was the first disputes. And the first dispute resolution was between, when the first yajna took place. So the issue was who will be the first Bhagwan who will be worshipped. So the dispute was between Shiva and Vishnu and Brahma. And finally it was resolved by Bhrigu Rishi, who finalized that it was Vishnu who will be the God. So this was how resolution of disputes used to take place. And first mediation, if you go back into the Hindu mythology, it was the 4 sons of Brahma, the Sanak, Sanat and Sanatan, who gave Shrap to Jay and Vijay. And because they were the Dwarpals of Bhagwan Vishnu, so Bhagwan Vishnu came there and he mediated. He said, okay, you may be born as a Rakshas, but I will come back and I will give you moksha. So that resulted in the birth of Hiranyakashyap and Hiranyaksh and Ravan and Kumkaran and Kans. So this is how I'm only telling you how the resolution of dispute used to take place. So now let's go to the modern world back again. So let's go to the next slide. we read the dispute. How does a dispute come into existence? Now, this is very, very essential for you to understand, because when the client comes to you, he's already having a dispute. But then you must understand as a lawyer that what has resulted into a dispute. So the first thing for every dispute is there has to be a relationship, or a contract. If there's no relationship or there is no contract, so relationships can be, because when you talk of relationship, I'm talking of relationship beyond contract. So there may be, tortious relationships also. And then there has to be a consideration. In every contract, there is a consideration. So most of the disputes come in when there is a consideration. So breach of the contract comes if the consideration as promised is not paid. And between the relationship, there is some mutual understanding. If I do this, you do that. So in every dispute, there is first thing is two parties has to be there. And then there has to be a breach. So now when there is a breach, now you understand it, the breach is basically takes place when one person does not do exactly what he has agreed to do. Now that normally happens because either he becomes too intelligent, he realizes that he made a wrong contract. So instead of challenging the contract, or instead of entering into a fresh contract, it results in a breach of contract. Now in today's world, let's take the very present situation. There's a large number of breach of contracts so far as the payment of rent is concerned. And that is going to be a major issue after this COVID opens up. Because you can't pay the rent. You can't pay the salaries. Now, the entire thing is based on a particular presumption. And the presumption was that the business will continue to move on. So if I'll have business, I'll have money. If I have money, I'll pay my rents. If I have money, I'll pay my salaries. So there's a breach of contract. Now this issue, whether the breach of contract will be covered by this major issue or will not be covered by this major issues. Now nobody in the world really, in fact, presumed that this is a situation which may arise, but it has arisen. Now hereinafter, all the contracts that are going to be executed or entered between the parties will take care of this situation. That if suppose there's a situation like this and there's a lockdown, then I'll be liable to pay say 50% rent, 80% rent, 70% rent, or 30% rent, depending on the potentiality of the person or relationship that is entered into. Now this breach of contract can be settled. So there's always a story of a reasonable man. But normally the disputes take place when one of them becomes unreasonable. In all family disputes, you will find one person who is unreasonable. He wants to subsume the entire property. But if they come down to a conclusion, come down to a person who is an elderly person or an arbitrator, so there can be a mutual settlement. But when a settlement doesn't take place, so there's an inability to settle between the parties. And when there's an inability to settle between the parties, then we go to a third party, which is a process of a dispute resolution. So we go to the next slide now to see what is the ways of resolution of a dispute. Now, disputes can be resolved by 4 processes. The first is mediation. The second is conciliation. The third is arbitration. And the fourth is litigation. Now, in fact, most of us, since we know courts and we are lawyers, everybody thinks that the only way, and that is what earlier people thought, that the only way to resolve disputes was through a process of litigation. But then arbitration, because litigation has got a legal sanction. You see, what ultimately in a litigation you get is a decree. A decree which is executable again by a process of court or by a process of contempt. The strictly decree may not be, but if the order of the Supreme Court, if any of the court of record is there and the court order is not followed, then there can be a contempt of court and you can enforce it. But then the litigations, then the issue came that was not the only way to resolve it, because they were, again, as I said earlier, that there are in certain cases, the disputes involve a huge number of documents. The dispute was very complex. So therefore, what the idea was that they should be done by process of arbitration. Because litigation was treated as an end source. In a litigation, there has to be one side will win, one side will lose. There is no way to resolve the issues amicably. So there were arbitrations. The conciliations is again a degree lesser than the arbitration. And one of the basic conciliation issues came in the Industrial Disputes Act. If you see Section 18 of the Industrial Disputes Act talk of conciliation. So these were disputes between labor. So they were labor disputes. Now the idea was that labor cannot, these people can't spend their money on the lawyers. So there can be a conciliation between the parties where the labor unions were entitled to raise the issues, and it could be resolved by a process of conciliation, by a process of collective bargaining. So they were the conciliatory proceedings. And mediation, which is now taking more coming in vogue, I would say. And this is again because of the, we are entering into the fourth dimension, I said, fourth industrial revolution. Now people want to resolve their disputes faster. Now they don't want to go through a whole process of litigation. So they want to come out on the table, across the table, find somebody who can say, okay, mister, you are reasonable, and this is what is more reason. So mediation is perhaps the most softest way of resolving a dispute. But till now, one of the major issue is that in a pre-litigation stage, when you have a mediation, so there's in a pre-litigation stage, so that if you see that the stages is when you have a litigation and you don't have a litigation. So mediation is a process which can take place at both the stage, pre-litigation and post-litigation. But when it is a pre-litigation stage, it is more like a settlement between the parties. So when there's a settlement, then it can be done by anybody who's a third party. So you go to a mediator and he resolves your issue. So he listens to you carefully, and then he says, okay, according to me, this is a better thing. You be happy and this be happy. So it leaves, it's a very casual sort of a situation. And in fact, we also launched a EMAC, which is Electronic Media and Arbitration Center, to resolve these, to start the mediation processes. So this is the fourth way of resolving the dispute. Now let me go to the next slide, which talks of, when did the historicity of arbitrations. And this was in year 1700, a decree was issued by Chinese Emperor Kangxi. The emperor, considering the immense population of the empire, now this is exactly what is happening with us now, a great division of territorial property and notoriously litigious character of Chinese, is of the opinion that the lawsuits would tend to increase to a frightful extent if people were not afraid of the tribunals, and if they felt confident of always finding in them ready and perfect justice. Now pause here for a moment. Now the tribunals, when you talk about tribunals, we are talking of courts. So courts will have to give a perfect justice. That is where the truth and justice comes in. So this is a perfected justice. So one party wins, other party loses. It's not a middle situation. So therefore the king said, I desire therefore that those who have recourse to the courts should be treated without any pity, and in such manner that they shall be disgusted with law and tremble to appear before the magistrate. In this manner, the good citizens who may have difficulty among themselves will settle them like brothers by referring them to the arbitration of some old man. So this perhaps is the first official recognition of arbitration by one of the Chinese kings. Now let's go to the next step where we talk of alternate dispute resolution. That why alternate dispute resolution has got a an edge over the regular court system. Because one of the major issue is that it is private. So two parties can join together and in an informal meeting sort of situation. The environment is entirely informal. Now in that informal situation, you can get it resolved. Now, the very interesting thing which is coming up is, though the whole process is informal, but since there are a large number of retired judges who are heading these arbitrations, they still continue with the formal process. So it depends from judge to judge. So it depends from arbitrator to arbitrator. So there's a lot of flexibility in the procedure. And let me share an experience that I had with one of the arbitrations, where we filed our pleadings and the judge said, okay, you file all the documents, and we finished our pleadings within a period of say 2 weeks. And he says, okay, Mr. Gupta, the argument starts from tomorrow, or if you need 2 days to prepare, it starts day after tomorrow. And you can file he told both the parties that anybody can file any document till the arguments are reserved. The judgment is reserved and the arguments are concluded. And every document will be considered as admitted if the other party doesn't say that it is a forged document. So it was a very flexible procedure. And you believe with that we finished our arguments within 4 days' time. And we got an award in next 6 days. So if the arbitrators are bent upon it, and if the parties are really interested, now that is where the real problem of time schedule comes. So there's a time schedule within which it can be closed. But the problem always is, if you see there's a conflict, going back to the next slide where we talked about conflicts. So there's a conflict. When there's a conflict, all much earlier. Don't go back. No issue. So when there's a conflict, one party always knows, they are aware, party is always aware that they've done a wrong. So they've breached the contract. It is not that the parties are stupid. Everybody knows that he has done a wrong. You see, there's no case, there will be very, very few cases where both the parties think that they're right. In fact, the party who is not right, they really know that they are not right. So he will not be interested in getting a final judgment. So it is always a situation where one party will try to, will see that the litigation takes a longer time. Let's take a present situation. The people have not paid their rent, or people have not paid their salaries. Now, person who has not paid the rent, or person who has not paid the salary, or take another case where the builders have not given the house to the person who has booked the house within the time schedule. He is not interested in finishing the dispute at all. He wants to linger on the dispute. But in the arbitration, the arbitrator can be very strict about it and say, no, mister, this will not work. In fact, my given choice, I would say the arbitrator should work from day to day. There should be no adjournment in the arbitration final hearings. It should be mediations, conciliation, arbitration, they should be day to day. Because parties know exactly, once the documents are there on record, you have to fix your timetable. So there is a lot of opportunity. Now, let me tell you, as the students and young lawyers of the bar who are here on this, hearing this, there's a lot of opportunities to develop an ADR bar. You can have an expertise only in alternate dispute resolution, because the clients and the judges, the retired judges who are working as arbitrators, they are tired of the regular bar. The regular bar people, they go to the court, so they will always fix up in the evening and they don't have time for these arbitration matters. But nobody, as a lawyer, nobody wants to leave any case which comes to his office. So if you expertise yourself in alternate dispute resolution, you have a lot of potentiality. So there's a lot of potentiality in our alternate dispute resolution. And the beauty of arbitration or all this alternate dispute resolution is that the relationship survives. You see, in a court of law, typically you take examples, cases of 498A, when anybody who files a case for disputes of dowry and all, there's a tendency to make all sorts of allegations. And at the end of the day, when the court gives a judgment, then the whole relationship goes for a 6. But in an alternate dispute resolution, whether it's a mediation or there's a conciliation or there's an arbitration, the possibility is, and there's a lot of potentiality. And I've seen cases where we've done arbitrations and then relationship was so cordial. Okay, they said, okay, the dispute is over, let us be happy. So this is the way, this is the benefit of an alternate. I am a big, I say, supporter of alternate dispute resolution, according to me. This is something which must go on and on. And this is going to take place in the, the fourth industrial revolution. Now, let's again go to what arbitration is really like. So arbitration is, it's find its roots in the word which is known as arbitratus, means decided or judged. So that may be good for court of law also, but this started when the things were easy to be decided unofficially. Now, in all cases of arbitration, one of the very, very important thing is an arbitration clause. Now, there was a lot of dispute, let me tell you, a lot of dispute till recently, where the issue was that whether there is an existence of arbitration clause or the arbitration clause is not existing, whether it can be decided by arbitrator or it should be decided by courts. And finally, I'm really, really happy that the Supreme Court has put its foot down, and even the recent amendments to the Arbitration Act of 1996 makes it very clear that the arbitrator alone should decide that whether there's an arbitration clause or not. Now, there are a lot of difficulties in these arbitration clauses because in large number, when the people sign their agreement, they really don't see these clauses. People are more interested to see what are the terms and conditions of delivery of the goods, what is the consideration they are getting, but they don't go into arbitration clause. And let me tell you, all lawyers who are going to be, all students who are going to be lawyers, in all the agreements that you draft, please be clear of your arbitration clause. And in all arbitration clauses, you must have a notice period for conciliation. There must be a conciliation, and if there's no conciliation, then there should be an arbitration clause. And now again, coming back to what I said earlier, is that party who is a default, they don't want the litigation to be resolved. So in an arbitration clause, you must have a clause saying that the solo lawyer, the solo arbitrator appointed by the person who is aggrieved, will act as an arbitrator. Else, both the parties are free to appoint their arbitrator and a third arbitrator to be appointed by two arbitrators, so that ultimately the issues are resolved. So this is then, and if there is no arbitration clause, now this is another situation where there is no arbitration clause, but the parties still want to do an arbitration. In that case, the arbitrator should enter into an arbitration clause, get it signed by both the parties, so that the arbitrations can be carried out. Now, third is that in an arbitration clause, after arbitration clause, normally arbitration clause should not have a named arbitrator. Because you never know at what point of time the breach is going to take place. The arbitration disputes will arise, whether the person who is named in the arbitration clause is alive or may not be alive, or he may be biased. So therefore, there should be a free choice of arbitrators between the parties. So the best way is if the parties agree for a single arbitrator, or the parties agree for appointing their own arbitrators, and then they appoint a third arbitrator. But one of the major problem, let me tell you, a major problem which is coming with choice of arbitrator is that if one party appoints an arbitrator, the arbitrator so appointed, he's like a committed person to that party. And then there's a very difficult, so there's normally a dissenting note in most of the arbitrations by the losing party's arbitrator. Then the issue is of governing laws. Now, most of the contract laws are common across the board, whether it is Singapore or it is America or it is Commonwealth countries. So where the contract laws is concerned, it is simple common law. And then applicable rules of arbitration again has to be decided by the arbitrators. So they can decide it, or there are now standard. You see, the next one is the ICC is there, the Singapore International Arbitration Council is there, and there's another which we have started known as India Center for Fast Arbitration. Now each of these, there's a lot of push for institutional arbitration by even the government of India, and so the issue is that these institutions can have their own rules, but these rules are flexible. All rules are flexible. Ultimately, it will depend on the arbitrator himself how to take up the arbitration. The ICC was basically the International Chamber of Commerce. It is developed in London. So these are part of what I call as litigation tourism. And Singapore is again doing the same way, because when you go to Singapore and do an arbitration, you'll go with your family or you take a whole team of lawyers. So they all work. So this is why they evolved. But now in this post-COVID situation, you see there are a lot of institutions coming up which will be holding only an online arbitrations. So the next thing which is going to come up now, and be ready, everybody of you should be ready for online arbitrations, and you must support the online arbitrations. So, and then we go to mediation. I'll just have a slide for mediation because I'm again a very strong supporter of mediation over arbitration also. And I say mediation is a dynamic, structured, interactive process where an impartial third party assists disputing parties in resolving conflicts, though the use of specialized communication and negotiation technique. Now, this is very, very important. Large number of disputes, in fact, most of the disputes where there is a, where there is a known breach is because of lack of communication. Most of the conflict arise because there's a gap of communication. You want to say something, the other party understands it differently. It's not that they didn't want to have a contract, but the terms of the contract itself that they understood was different. Like a lot of expectation people have out of their family. Now then there is somebody you have to be specialized in communication, and then he must have a negotiation skills to negotiate between the parties. Here one party, here other parties, tell them their point of view, tell them their point of view, and finally come down to conclusion. Then all participants in mediation are encouraged to actively participate in the process. Mediation is a party-centered process in that it is focused primarily upon the needs, rights, and interests of the parties. The mediators uses a wide variety of techniques to guide the process in a constructive direction to help the parties find their optimal solutions. A mediator is a facilitative in that she or he manages the interactive between the parties and facilitates open communication. Mediation is also evaluated that the mediators analyze issues and providing norms, the reality testing, while refraining from providing perspective advice to the parties. You should do this and you should do that. Now, this is another, my idea to you young lawyers is that you can become, if you have got a very, multidimensional interests, then you can make a very, and if you think that you can make a good mediators, I think there's a lot of opportunity for online mediators. And people will like their issues to be resolved through mediation online. Now, this is going to be a very, very big business in due course of time. And I wish that the whole bar association of mediators come in. So you have got independent professional mediators, resolving the disputes, putting up their websites and resolving the problems. So there's an edge. So we go to the next where we say that there's an edge of mediation over arbitration. And there's a, certainly because there's an open communication. Again, in arbitration, there are a lot of issues is that professional lawyers come in. In mediation also you'll have lawyers, but in mediation you can still hear the parties. You have to hear the parties. So when you hear the parties, then you have a one-to-one communication. The distinction between arbitration and mediation is that there's no arbitration clause. So you can enter into mediation with respect to every dispute. But any mediator, let me tell you, any mediator who is entering into a mediation before, if there's no arbitration clause, you must have a mediation clause. You must get both the parties signed that they will agree with your mediation. And if you want a mediation to be done, you must get a mediation agreement signed. A mediation and an arbitration. So if it is not a mediation, the mediator himself converts himself to arbitrator and resolves the dispute. So there's a benefit of it also, and then there is to be, because otherwise if there's no arbitration or a mediation, which has got a legal, which has got the consent of the parties, it will have no enforceability. Then one of the party will say this is all trash of paper and it was done by fraud. So there's no strict pleadings in mediation. There's no strict procedure to be followed. It's a simple settlement by intervention of a third party. and the binding nature can be done by process. So you can have a binding nature by entering into an agreement prior to entering into a arbitration, but prior to entering into a mediation. So then, so this is something you have to be very, very careful in doing. Now, this is again arbitration over courts. So arbitration is basically private proceedings, usually behind closed doors, useful if franchisees involved in trade secrets know how. So this is again, which is very important, is going to happen in the, because in the fourth industrial revolution issue where robotics is there, and there may be IPR disputes. Now, people don't want to really tell everything put it in the pleadings, or put it on the board, or put it as a part of the code from which the trade secrets can be leaked out. So the arbitrations will be very, very important in basically in these cases. Then parties can appoint a sole arbitrator or panel of arbitrators. Parties know who will resolve their disputes. Then arbitrator can be an expert in the field, as we already discussed, helpful in the area of technical and nature of requires special knowledge. In certain situations, arbitration award may be enforced in country where loser assets are situated. Useful in disputes involves cross-border element. This is going to be very, very important because you may be doing a dispute where one of the parties is doing a litigation in, say, suppose an American party doing a litigation, doing business in India, but they may have no assets in India. So you can still go and get them executed out of India. Now we go to the next issue is normal arbitration clauses. Oh, just skip it out. Okay. Now this is one of the earlier, like I showed you the Chinese issue. This is the will of George Washington, which I just wanted to share with you because it makes a very interesting reading. He said, George Washington said, that all disputes, if unhappily any should arise, should be decided by three impartial and intelligent men, known for their probity and good understanding. Two to be chosen by the disputants, each having the choice of one, and the third by these two. Which three men then chosen shall be unfettered by law or legal constraints declare their sense of the testator's intention. And such decision is to all intents and purposes to be as binding to parties as if it has been given by the Supreme Court of the United States. Now, that was the confidence that George Washington showed in the arbitrators. So now let's go to the next issue of what is a standard arbitration clause. Now these are the standard arbitration clauses. The simple arbitration clause is that all disputes arising out of the contract shall be submitted to arbitration. But this, according to me, does not make much sense. Then typical arbitration dispute that you are finding in most of the arbitration clauses. Any dispute arising out of or in connection with this contract, including any question regarding the existence, validity, or termination, shall be referred to and finally resolved by arbitration in, say, Singapore, in accordance with the arbitration rules of SIAC, as amended from time to time, which rules are deemed to be incorporated by reference to this clause. Now, according to me, this typical arbitration clause is also not complete. So what I suggest is a recommendation arbitration clause, which you'll find on the next slide. So this is the arbitration clause which we put in all the contracts that we are drafting. In the event of disputes or difference arising between the parties under this agreement, the aggrieved party shall send a communication to the other party stating the issue of dispute, and the parties shall meet to mediate and conciliate the matter and arrive at an amicable settlement thereof within 15 days of the receipt of the communication. In the event the parties fail to arrive at an amicable settlement within 15 days of the dispute having arisen, the aggrieved party shall issue a notice to the other party and appoint its arbitrator. Now, its arbitrator is very important. Its arbitrator for adjudication of the dispute by arbitration. The other party shall, within 15 days of receipt of the notice, appoint its arbitrator, and the two arbitrators shall appoint a third arbitrator, or the parties may agree for arbitration through a sole arbitrator. If the other party fails to appoint the arbitrator, now this is taking care of a situation where the other party will not appoint an arbitrator. So if the other party fails to appoint its arbitrator or agree to a sole arbitrator, The arbitrator appointed by the aggrieved party shall act as the sole arbitrator and enter upon reference. The dispute shall be adjudicated according to the provisions of Arbitration Clause, Arbitration and Conciliation Act 1996, and when it from time to time, the arbitration proceeding shall be held in Delhi, New India. Because I am a great promoter of arbitration tourism to India. Now we are coming to the new situation where we will have paperless e-mediation or e-arbitration, whatever it is. So we will have a paperless pleadings, evidence, and proceedings. There will be remote participation as we are having right now on this Zoom meeting. And then presentation and transcription of pleadings, evidence, and submission in multiple languages. Now this is going to be very, very important. Because today Google and everybody, even Supreme Court has started, translating every document into 14 languages. So the multiple languages. So when you got see Canada, even the judgments today in Canadian Supreme Court are there in French. So you can have German, French, and other languages which are prominent, and there may be arbitration. So you can have evidence and submission in multiple languages which can be translated into English and even into Hindi if you want to hear them or read them very clearly. So this is what the e-mediation is there. And finally, let me tell you what my suggestion to all is that we must make India as a hub of arbitration and mediation. Let me tell you something about my understanding of the legal industry. You forget about the 7 major countries. Kindly forget about them. And they are England, USA, Canada, Australia, New Zealand, Singapore, and Hong Kong. Now there are 204 countries in the world. There are 123 democracies in the world. So out of 123, if you remove 7, or if you remove some another 15 or 20, who are European countries like Sweden and Switzerland, who don't look at India as a very big, they look down upon India and not look upon India. There are more than 100 countries. Believe me, this is my experience, and I attended the Commonwealth Conference in Zambia last year. There are 100 countries which look at India. They want you to be the key holder of this mediations and arbitrations. So whenever you enter into agreements with these countries or you're them, then you can choose your place of mediation, and then commercial players, draftsmen, and it is not lawyers. And who are the drivers of certainly speed, efficiency, absence of risk, mediation tourism. How to create new arbitration venues and the choice of global market, clear rules and immaculate execution. So India has a massive commerce and talent in its borders, is ready for a launch. Now we have already launched. Let me tell you, we have already launched. The Supreme Court has shown a path for creating a global center for arbitration. So the young bar, let me tell you, by 2030, 2040, 2050, you will be a leading country. So you must create a leading hub in arbitration and mediation. Thank you. It's a great opportunity for us all.
Thank you so much, sir, for sharing your insights on a number of international and domestic aspects and how drastically the industrial revolutions have evolved ever since the first industrial revolution to the fourth industrial revolution, and how globalization has reached its zenith and significantly affected the scope and the ambit of alternate dispute resolution, along with throwing light upon the various fields wherein ADR could be resorted to in order to resolve disputes amicably, and at the same time elucidating upon the history of disputes. Sir, with your permission, we would now be taking questions from the viewers.
Certainly.
Okay. So, sir, the first question is, can globalization be deemed to be regarded as a core characteristic of modernity that has steadily progressed since the first industrial revolution to the fourth industrial revolution?
Yeah, of course it is a progress. You see, every step by mankind. One of the major issues you people should understand is that we are now a world of records. Today, when you go to Wikipedia, everything is recorded there. Everything which is in form of books. I don't know how many of you are aware how Wikipedia really works. Every one of you, let me tell you, every one of you can be an editor on Wikipedia. The only thing Wikipedia requires is that there should be a pre-publication of any information or data that you're putting on the Wikipedia. So everything now is based on, there's a whole set of information that is available now. Now on this, when you work and when this information will be, dealt with in an artificial intelligence or the computer working, I don't know how many people you understand it. It's like a chess. In chess, there are, when the first game was with Bobby Fischer and he won and then he won and won. When ultimately Kasparov lost to computer. Now that was a development of artificial intelligence, because 10 years the computer continued to have competition with all the grandmasters. So it had all the moves of the grandmasters in its system, and from that it evolved a better move. So it virtually had all the moves and not implemented to lawyers now or implemented to court. So when you have all the judgments with you, and all the database is there of the judgments is there is available on the cloud, then when you file a pleading, then using this again part of the globalization issue, then when you put a pleading, whether it is in India or whether it is Singapore or it is Canada, when you have a case coming from America, the moment you put it into a system, it will tell you, mister, where are you going wrong and which are the cases which are supporting you. So there's a evolution, and there's going to be dramatic evolution. And let me tell you very clearly, whatever has taken place till now is not even, according to me, is not even 2 to 3% of what is going to be evolved further in next maybe 100 years. We are still at a very primitive stage of globalization.
Thank you so much, sir. So the second question is, according to you, is the fourth industrial revolution, disrupting the dispute resolution mechanism by any chance?
Disruption is a part of the fourth revolution, but disruption is also a part of creativity. You must understand, everything, after all, industrial revolution disrupted the agricultural revolution. Now today you see everybody is using a mobile for a photography. Now the Kodak, which was one of the largest film producer of films, is gone. But then again, the issue is, it is evolution. The disruption is a part of evolution. Once you come to an end, it's always a new beginning. There is nothing in this world which will cease to exist. There'll always be a reformation, because everything, let's say a seed, when it has to grow into a tree, it has to disrupt. You may say, no, you can't have, this should not have. A caterpillar, when it is to become a butterfly, the whole thing has to disrupt. No, it has to break the shape in which it is existing. So we are evolving. Since we are evolving, there's bound to be disruption, and I am happy about this. This is where you have to keep your mind open, that nothing is constant. Everything is changing. Everything is moving. There's a disruption, but disruption is leading to creativity, or disruption is leading to destruction. In a civil society, which we are there, and I'm a great supporter of it, that we must have a disruption relating to creativity. So all disruptions are happy. I'm happy about the disruptions.
Okay, sir. Thank you so much. Sir, next question is, what, according to you, should be the effect of arbitration clause in an unstamped agreement, as the view by the courts is differing?
I didn't get that. What did you say? In
yes,
the unsigned agreement?
Yes, sir. Unstamped agreement. Yes, unstamped.
Where do you get that? Unstamped, because there's nothing like a stamp. In the registration, you're talking registration. After the documents can be, normally the document, today we have electronic, let me tell you, today all the contracts are electronic contracts. So there's nothing like a stamped. So what earlier used to be, there used to be a registration of a document. The agreements, all the rent deeds were registered. But then again, there's a registration fee, so people are trying to avoid it. Then the issue came of notarization. So you notarize the agreement. So that gave the authenticity to the agreement. Now you have got an email, because all the agreements are entered into on the electronic format. So today there is no issue, let me tell you, no issue of stamped or unstamped. If somebody comes up and says this, I don't agree with the agreement, then the other party can always establish the authenticity of the agreement by virtue of the all the emails that have transacted between the two. See, let me tell you an example. If I am sitting in India, I am sitting in Delhi. I sign a document. Now, how do I enter into an agreement today? So what I do is, there are two ways of doing it. Either I put my digital signature on the agreement. You see, I draft an agreement in MS Word and put it on put my signatures in a digital format. Now, my digital signatures are what? They are in fact a scanned copy of my signature, and I paste it there. Or the other way out is that I take a printout, I sign the document, I scan it again, and I send it to you. Now, this is one side of the party. Now, when it goes to the other party, now what is the other party has got an option? Either the party will do the same thing, either they'll put a digital signature, by means they will have a stamp, cut out their stamp, crop it up to a size, and then paste it there. Or the other way out is they take a printout of it, and they sign it on the printout, and then they take a scan copy. So both of them has a scan copy. And now then it goes to the witnesses. Now, all this process, you see the whole change. But then there's a change. There's a line of emails which will show that this agreement is validly executed. Now, the purpose of a stamped or an unstamped document is only to show that it is validly executed, so it can be taken as part of the evidence, or it can't be taken as part of the evidence. And therefore, the Supreme Court, I don't think there's a conflict there, because Supreme Court is very clear that once there's an arbitration clause, and if the parties have agreed to it, because there can be oral agreements also, but there can be no oral arbitration clause, of course. So if there's an agreement between the parties and the party contains an arbitration clause, then the arbitration clause is binding on the parties.
Okay, sir. Thank you so much. So the last question is, what tips would you like to give to our future young lawyers who wish to enter into the arbitration field?
What test? What advice?
What advice? Yes, sir. What advice? What tips?
I think there's a huge potentiality of arbitration. But let me tell you one thing very clear, that ultimately arbitration is only a procedure. Arbitration is not a substantive law. It is only a procedure where you can, in a very casual dress, you can appear before an arbitration. You don't have to go to court and bow down to the judges and wait for the time. So here you can save your time, and you are not in a very formal situation, and it's very casual. So for a lawyer's career, let me tell you, for a lawyer career, it is a long career. It's not, there's nothing short in this career. So you continue to learn slowly and slowly. So learning of a procedure is not important than learning the substantive law. And that is what in one of the slides I said, that you must know how your client does his business. So what you really have to learn is the nature of the business of your client. So if your client comes to you for doing an arbitration or construction contract, you must know the construction industry. If you say, now let's take an arbitration relating to sports industry. Now, unless one of the major disputes in the sports industry is arbitration is drugs cases. You see, arbitration immediately if you're tested, there's something you're tested positive in a drugs, they send you to an arbitration, and there's a sports arbitration going on. Now you have to understand the impact of each drug. So this is now getting into medicine, pharmaceuticals. And then what is the impact of that drug? Who gave you the drug? We have done 3-4 major cases on this. This girl, there was a lady girl who was we did a case for a shot put Olympiad who was going to participate in 2020 Olympic, and he was banned by TADA. And the major problem was he was tested positive, but he was happy now that 2020 didn't take place. So you have to learn the business to be a good arbitrator for anyone. Both ways. If you have to expertise as an arbitrator, you have to learn it. If you want to do a case for a litigant, you have to learn it. So there's no difference between the career of your career as a lawyer, whether you are appearing in a court of law, or you are appearing in an arbitration, or you're going in a mediation. You see, you have to think like a lawyer. The major issue is a lawyer has to think like a lawyer. He may be doing anything, and it becomes a part of your system. And once you learn to think like a lawyer, and when I say I think like a lawyer is basically you must think like a judge. So they're not like nothing like a thinking like a lawyer. In fact, it's like thinking like a judge. That how will the judge take your arguments? And I think there's a very, very important way of thinking, because he has to listen to the both sides and decide it. So you should not make an argument which doesn't make sense. You must be very clear as to where your client is speaking the truth and how to go around. Here you can never go against the law. You have to go around. Maximum you can go around the law. So you have to understand the facts and you have to understand the law clearly, whether you're doing arbitration or you're doing a court of law.
Okay, sir. Thank you so much, sir, for answering all the questions and queries and providing us with your insights on the various aspects of globalization and how it has affected the ADR mechanism in the last few years. It was indeed an honor to have you on board with us, and I would like to thank you on behalf of the entire team of Legal Desire and the alternate dispute resolution team for gracing the virtual conference with your presence and providing us with your time on a Sunday afternoon. Thank you so much, sir.
Thank you very much. The only thing I think we have overstepped the time. But that's how it works. This is again it's like an arbitration because it's not a very strict court sense. So you don't close it at 40 minutes and say, okay, bye.
Yes, sir. Thank you so much, sir.
Thank you very much. And I wish you all the best of wishes to your team so that you can really take the whole thing forward. And I think this is a very great initiative that you're doing. And you must continue to do it up and pick it up and have the best of the people around and best of the audience around. Thank you. Have a
Thank you
great
so much, sir. Moving on, I would now like to take the opportunity to introduce our next guest speaker for today, Advocate Pallavi Pratap ma'am. Advocate Pallavi Pratap ma'am is the Managing Director of Pratap and Company, and she is an advocate on record in the Honorable Supreme Court of India. Ma'am specializes her practice in both criminal and civil matters. Pallavi ma'am, who was a former investment banker, brings with her over a decade of experience in the field of litigation. Ma'am has done her honors in history from Jesus and Mary College, Delhi University, and has completed her master's in business administration with specialization in finance from La Trobe University, Melbourne, Australia. Ma'am completed her LLB degree from Lucknow University. We are truly delighted to have Advocate Pallavi Pratap ma'am with us on board today. With this, I would like to cordially invite Advocate Pallavi Pratap ma'am to share her views and insights on how COVID-19 will have an effect on the future of arbitration. The floor is all yours, ma'am.
Thank you so much for having me here. I hope I'm audible and visible both.
Yes, ma'am.
Yeah.
You're audible.
All right, wonderful. You know, Aruneshwar sir has actually left very little for me to speak because he's practically covered everything end to end. So, you know, there is basically nothing really left for me to add. But nonetheless, since I'm supposed to make a little bit of a contribution, I thought that, you know, I can basically share my own experience in terms of conducting an online, you know, arbitration that we did while the COVID lockdown was on. And I feel that sharing this experience will probably bring about you know, it will definitely facilitate a lot of people who are looking to do online dispute resolution through, you know, virtual medium or video conferencing. But there are a couple of things that I would generally want to tell you, and I will actually give the details as well. There is a very interesting paper which was presented by the NLU Mumbai, which is called as Virtual Arbitration in India. It's a practical guide, and the link I will send to the Legal Desire team, and they can refer to it for people who are interested in looking at virtual arbitration. Now, how we started with virtual arbitration primarily was that our date for a physical arbitration hearing was scheduled for, I remember, 29th of March or something. And 23rd of March, we had the lockdown. So Justice Sikri was the presiding arbitrator in that matter. And so initially we got it adjourned for about a month's time. It was the first hearing that we were supposed to have. And but however, since the lockdown again extended, he directed, and this is something that is important for everybody to note, that arbitration is primarily not governed by the Evidence Act or CPC. So if there is an arbitral tribunal, they can develop their own rules. So we had a 3-member arbitral tribunal which consisted of retired judges, and therefore Justice Sikri then directed us, saying that we should explore the opportunity of virtual hearing. And that was something that was that we were already doing in Supreme Court, because Supreme Court, interestingly, within 10 days of lockdown, we were all looking at matters of urgent importance which were coming through video conferencing, and we saw that different courts actually adopted to the entire virtual hearing and video conferencing method very quickly. So then, once Justice Sikri gave us the go ahead, we explored the different areas that we could have looked at, and there was a possibility of doing it on Zoom, just as we are doing it just now, or through WebEx, Cisco WebEx, or different other platforms which were available. However, what we did was, specifically my team, at least, we decided to reach out to other people who are specializing in virtual arbitration. So there are different companies. There's one company called as CODR. I think this is a Bangalore-based company, which is extremely good as far as online dispute resolution is concerned. And they came to our rescue. Very cost effective, one. Secondly, they have this whole registrar who is there, who will, one, take both the parties through how the entire setup will be done, in terms of how you have to log in. There are these breakout rooms that they have made within the setup of, let's say, the online mechanism itself. So, for example, if the tribunal is there and then I'm there and I have my clients also who are watching the proceeding, and I have to take an instruction. So typically, before that, what used to happen was people would use WhatsApp, and then they would ask for instructions. Whereas with a breakout room, interestingly, what has happened is that, without the tribunal or the other side lawyers actually knowing what kind of an interaction I'm having with my client, I could just enter into a breakout room and take instructions, understand if there was a specific answer that was required to be made. So I think this whole technological intervention kind of brought about this excitement, definitely. And also, we were entering into technological areas, and we were learning things so fast, which was something that, if we were to do it in a non-COVID time, probably this kind of an adaptation would have taken more than a year for people to adapt to technologies in such a manner. But with this, with this urgency that came as a result of COVID lockdown, we saw that, the adaptation was really quick. Within a week's time, we were ready with everything in terms of how the arbitration, online arbitration, would take place. Where would we have, our data stored? How would statement of claim be sent across? And this was completely paperless. So one would understand that if there is an arbitration, where you have, of course, 3 judges tribunal, it was a huge coal-related arbitration that we are doing. The bulkiness of files itself is huge. So we were not really involved with a lot of paper transaction. Justice Sikri had given us the order that, you can file every document paperless, and we did that. So I feel that, stricter adherence to timelines definitely came in. It was definitely very cost effective. So we did not really see that, it was actually probably 1/3 of the cost that one would have seen as far as physical arbitration was concerned. And also, there have been, areas where we felt that there could be, struggles as far as adopting technology is concerned, but I think we did not really face that. The second biggest challenge that we had was how much of a security would a software or an online dispute resolution mechanism, or the intervention that we are using, the platform, how safe would our data be? and we realized that it is extremely safe. They give you a specific data which is available on cloud, which is available for both the parties to look into. I think the transaction becomes really easy and also extremely cordial. The other, I think, practical considerations, if we talk about, because I'm asked this question quite a bit as far as online dispute resolution mechanism is concerned, is about how effective do you think this would be going forward. Now, if we look at it, Supreme Court also is looking at, starting with physical hearing a little bit. I think about 2 or 3 benches will start from 10 days or so. But the practicality right now in terms of looking at the numbers of COVID cases, it seems that video conferencing is still going to stay for another 6 to 8 months. So if you look at the timelines that one has to adhere to as far as arbitration is concerned, then if we are looking at only physical hearings of arbitration to take place, then those timelines can never be adhered to. So the virtual arbitration mechanism that we are seeing, even though there are, voices that are made that, um, technology is not very efficient, or there is a problem with, video, audio related uninterrupted service is not really there. But in my experience, what I could see, it was completely uninterrupted. People, so we were all, so I was in Delhi, certain arbitrators were in different parts of India. The other party was in Chhattisgarh. My clients were in Orissa, and we were all together in one online arbitration hearing, virtually present and doing a very effective arbitration on that hearing. And it was so simple and so easy that I feel that that definitely helped in curtailing cost for both the parties, because they were not really sending their legal counsels over here. Travel, etc., and staying, etc., was completely done away with, and the prices were completely subliminal. I also felt, and this is something that everybody else also felt, was that it was easy to refer to documents. A lot of times people feel that, screen sharing is something that you have to do. So how safe will that be? But when you have your documents stored in the cloud, it is very easy for any parties or for the honorable judges to, just click on that link and be able to download specific documents from the cloud. So I feel that data security and confidentiality in that sense was not really a problem that we faced. And if you look at it, Singapore, SIAC, for example, MIAC, Mumbai International Arbitration Center, they've all been doing and also exploring opportunities for online dispute resolution mechanism. And I feel this is probably one of the best ways to adhere to a timeline, because arbitration has to be time bound as far as India is concerned. Even though the Honorable Supreme Court has extended the limitation as far as Arbitration Act is concerned or Negotiable Instrument Act is concerned, yet if there is an opportunity and if there is an option which is available to you where you can finish your arbitration in a time bound manner, then I think online dispute resolution mechanism is definitely something that one can look at. But I have heard a lot of uh, voices of disconcert where they've said that how do you go about when you have a cross examination that you have to do, or if you are looking at oral, you are going to have witnesses who are coming. So typically an arbitration could be based on documentary evidences, where it is not so difficult, because then you are doing your submissions just as I'm doing it just now in a Zoom hearing. But when you look at it in terms of you have a witness who you have to cross-examine, there have been so many questions that comes to one's mind, because how is it that you're going to ascertain that the witness is not being coached? Because right now, if the camera is focused on me, how is it that somebody can know that someone standing right behind the camera is not coaching me? Or, for example, if there is a tough question that comes and suddenly the person logs out and you are just left looking around, not knowing what happened to the witness. I think these are practical problems that one feels that one would face if oral witness is allowed. But interestingly, it is just a development that happened last week where CBI courts in New Delhi, in Rouse Avenue, are starting with examination of witnesses through video conferencing facility. There are specific places that have been made, and they can go over there so that the environment is controlled and that there is no influence or the external influence to coach the witness. So I think if there are problems that one sees or challenges that one sees as far as uh, um, technology is concerned, there are definitely areas where one can find out solutions to. So it is not that difficult right now to overcome those challenges. Like sir said that transcription etc. And translation is happening in countries, especially with Supreme Court having translations done in so many languages. um, Transcription specifically as far as arbitration is concerned has become very easy because of online softwares which are available, which comes with these third party management service providers who are there. So I feel personally that if you have an internet facility and you can figure out, if you have both the parties agreeing, more importantly, to online dispute resolution mechanism, I think that's a very good way to move forward. However, because the Arbitration Conciliation Act is completely silent on virtual hearing, I think this has to be decided by the arbitral tribunal or the sole arbitrator who's appointed. So, looking at all of this, I feel that certainly there is a change that has been brought about, and at a very fast pace, that such a change has been brought about. There was a question that somebody had asked to sir, and I just wanted to add on that. It was about whether or not the stamp fee has been paid on an arbitration agreement. What is the stage? Because there are two different judgments. There's one judgment by Justice Bobde, and the other one stands true, which is Justice Nariman's judgment. In our case also, there was one of the cases that I've done. The arbitration agreement was not stamped properly, but it is up to the tribunal members. What they do is typically that if the stamp piece has not been paid on the arbitration agreement, then what they can do is that they can adjudicate in terms of whatever the stamp fees is, and with the penalties etc. On the date of hearing they will tell you, and once you've made the payment, it is only whenever you've made the you've paid up the stamp fees, then the arbitration starts. So this is one manner in which one does come out of this problem of having inadequate stamp fees paid on an arbitration agreement. But most of the time, like sir said, arbitration, there is no such thing as a separate arbitration agreement which is signed. Typically, it is a clause which is there in the parent agreement. So, looking at it to be registered, I think, is not something that typically happens. And rarely is this objection actually brought about as far as arbitration is concerned, unless, of course, one party doesn't want to really pay and wants to just embroil into all of this. The other aspect of when I'm talking about future of arbitration is that even though we've seen the latest amendments, and Justice Nariman spoke really vividly on in one of the GAR sessions also about the latest amendments that have come of the 2019 Amendment Act. The idea, I think, is still where we are kind of stuck, is that like sir said, like Aruneshwar sir said, that execution after the arbitration is over and the award is there, execution becomes a problem. So I remember right before the lockdown, there was a GAR session which took place in Delhi, and one of the concerns that the councils, general councils made was that they are sitting with some um, the last figures I don't really remember clearly, but India had some 700 crore worth of arbitral awards which was sitting there because there was no execution that had taken place. in terms of execution proceedings that are left as far as arbitral awards are concerned. Because what happens is typically that if there is an arbitral award which is in favor of someone, you would see that then after the arbitration award has come, someone or the other will approach the court, and then litigation starts right after arbitration is done. Then the efficacy of having an arbitration done is completely redundant, because the whole idea of entering into arbitration was to avoid litigation. But if a section, if a challenge to an arbitral award is being made time and again, then I think the entire reason for moving on with arbitration and the expense that one incurs as far as arbitration goes, because arbitration is not something which is very cost effective in that sense, because there is as per the new act, if one would see, there is a significant amount that both the parties have to pay when arbitration takes place. So it is not something, even though there is an entire dialogue about how cost effective it is, and in some manner it is cost effective, but I find personally that arbitration also becomes expensive for both the parties. So if after an arbitral award has come, if there is no quietus which is given to the entire dispute, and again a litigation is started after the award has come, then I feel the entire purpose of ADR just loses its track on which it was. So I feel that the future would become will definitely strengthen if both the parties actually go with an open mind and ensure that whatever award comes is something that they might be open to looking at accepting it, and instead of challenging it into the courts. So I think I have taken about 20 minutes to speak. If there are any queries, then I would be very happy to answer them just now, because I think there is a time constraint.
Thank you so much, ma'am, for sharing your insights on how ADR could be deemed to be regarded as the next thing forward. And with the current situation, resolving disputes through alternative methods seems the perfect way forward. So we'll proceed with the questions, ma'am. Ma'am, the first question is whether an arbitral award passed by the arbitrator or the arbitration institution, which is issued electronically without a wet signature, can be deemed to be regarded as capable of being enforced in the jurisdiction in which the paying party under the award has assessed.
So I think that this problem has started to be solved in the sense that now there are all these digital signatures which are available. One, secondly, because the arbitral award has to be stamped properly, for that in the SHCIL, from where you can actually download stamp papers, this is all working just now. So there is a lot of I think a lot of people are scared about the fact that even if I go with the online dispute resolution mechanism for the remaining part of my arbitration, and the award comes in, it will not be executable. That is actually not the case, because right now everything is available. You can basically download, and everything is available just on the click of a finger. So thinking that it will not be executable, I doubt is the case. However, yes, execution, because most of the lower courts are not working just now, so execution of an award will definitely be a problem, because that will not come under the urgency clause upon which most of the lower courts are working right now. But otherwise everything is available online. You can get your stamp papers also. You can, the arbitrator can put the digital signature. Everything is available right now. It's all going very it's going very fluently. It's not something that one sees a lot of roadblocks in.
Okay, ma'am. Thank you. Ma'am, the next question is, in light of the pandemic, the arbitration proceedings are conducted online. So, ma'am, according to you, what measures do the parties need to take in order to protect themselves and their arbitration proceedings online, basically to maintain the secrecy, because it may be prone to hacking,
Correct.
privacy concerns?
Correct. So this is where I at least suggest, and I think a good idea is to engage services of a third party management services. For example, like we engage CODR, and there are different other companies as well. I will share the NLU Mumbai's paper also, that provides you a very good guideline as to how you can look at security concerns and how you can get over with them. But most of these places, so CODR, the password itself was some 36 letters which were there. So 36 letters, believe me, was they showed it to us that it was difficult for anybody to hack. So typically, if I'm doing a Zoom, I have what, six numbers, six number password that comes in. But when you are looking at a CODR or any specific third party services provider, you will see that their password itself is some 36 letters, and it is completely governed, and there is a lot of cyber security that they have. Also, you have the option of not uploading your documents in their system, or in their cloud service provider, whatever the cloud platform they are using. You can only maybe use that platform just to engage into oral hearing, and then you can use your document exchange through emails or through Google Drive or OneDrive, or whichever drive you are using. Everything these days is on cloud. So I feel that technology has really helped us in terms of, as a matter of fact, a lot of you who would be there, you may want to see Chandralal sir. There is Chandralal sir, who's a senior advocate from High Court. He has done a video, and it is available on YouTube, where he talks about how he has primarily, converted all his files into e-file, and how he's doing his case management system on his own. I feel that is something that, even my office has started to do. We've started to put everything on the cloud, on the drive. Security concern will only come when you're using open share platforms, for example, like Zoom is there, or Webex is there, where you don't know exactly how much of a hacking can happen. But where there are third party providers who are only specializing into this, I feel there is very limited chance of hacking. At least we did not feel any such problem, and nor have I heard from anyone who's been using the online dispute resolution mechanism.
Okay, ma'am. Thank you so much. Ma'am, the next question is, do you think remote hearing can be deemed to be regarded as the way forward? And how does an alternate dispute resolution service function for litigants?
For litigants, so if you're looking at ADR right now, Supreme Court is doing their mediation. Supreme Court has a very big mediation cell, by the way, and very effective also. Supreme Court has started to do their mediation through their video platform that they have. Delhi High Court has a pre-litigation mediation service, which they have also started, where I think it's through WebEx only that they do. Um, Similarly, I feel that for litigants, if we're talking about litigants here, then for them it is accessible. Uh, because I see, when we are arguing matters before Supreme Court, and some client who's probably in one of the remotest um, village in Devariya in UP, which is the eastern part of UP, where he's able to um, come online and see virtual hearing, and see if his counsel is actually making submissions or not. I think we've basically bridged that digital divide in that sense. Uh, and this is definitely cost effective. I mean, if you have a data pack with you, then you are not really paying. For us, I'm telling you, for the CODR, I think one session did not even cost us more than 10,000. It was between 5 to 10,000 rupees, which was again shared between the two parties. So it is actually that effective, and it is not that you are spending so much money on getting huge briefs photocopied and sent to everybody, ensuring that the service is done. The registrar of the alternate dispute service provider will himself ensure that all the services happen, because I think one of the biggest problems that as lawyers that we face is that service typically would not be affected on time, or some or the other problem comes in, especially with the COVID lockdown. I think this whole idea of exchanging emails and ensuring that service is happening through that or WhatsApp, messages can be also considered as service. I think that's a huge step forward, and it has definitely become cost effective for litigants. I think that's a very good thing that happened suddenly within 5 months, that we've seen the entire legal arena shift to technology based platforms and using them effectively.
Okay, ma'am. Thank you. Ma'am, one more question. Will the COVID-19 pandemic be deemed to be regarded as a game changer in the course of international arbitration?
I think yes, it is. It is definitely being looked upon like that. Uh, I think there will be issues that we will see, though, in terms of the seat and venue aspect of arbitration, that has always been a very difficult area as far as domestic arbitration is concerned, and definitely an area where international arbitrations. We typically see that there is a lot of confusion that happens, because, for example, I'm doing an international arbitration right now. It's pending for appointment just now. It's a case that I'm doing in Supreme Court, where the problem is that the arbitration clause is there in the invoice now, and it is completely silent on as to where the seat will be or which will be the venue, and then appointment of arbitrator is also not written very clearly, and we are invoking arbitration basis and invoice. So these practical challenges um, are coming every day, as far as when we see that there is a lot of international trade that is happening. Like sir said, that arbitration clause is so important in agreements, and you see that they simple agreement actually lacks an arbitration clause, which then leads into litigation which keeps going on for years. So I think if international trade is increasing, it is important that arbitration agreements are signed between two parties, and seat and venue related problems are sorted out with the agreement itself. Because then SIAC and everybody else, I mean, ICC has such amazing, I'm told, sir has appeared before ICC. I feel that the kind of infrastructure that they have, we are still very far away from reaching to that level, where everything is over transcription, and an entire arbitration hearing would finish off within 1 to 2 days, in terms of whenever there is a setup that happens. Whereas in India, it can go on and on for 2, 3 days, 4 days, depending upon the availability of the arbitrators and all.
Okay, ma'am. Thank you so much. Ma'am, one last question. What tips would you like to give to our viewers and future lawyers who wish to enter into this field and practice arbitration?
I think arbitration is an interesting field, very, very, very interesting field. But my biggest tip to everybody who wants to pursue arbitration as a career is to follow one, all the Supreme Court judgments and the Delhi High Court and Mumbai High Court, Bombay High Court judgments that have come as far as arbitration is concerned, because it keeps changing. With Hardy, very recently, last year, there was an entire confusion as far as seat and venue was concerned. So keeping up with the latest case laws is very important. Understanding how to draft a very good statement of claim or statement of defense, or if you have to file a counter claim, understanding the drafting part of it, I think, is essential. It is extremely essential, because a lot of people think that it is just like drafting for civil suit. It is actually not that easy, because statement of claim, you're basically bringing about your you have to um, eh, look at the different headings of claim, and you have to justify every single heading of claim. So how is it that you do that? I think that is a very important understanding that any budding lawyer needs to know, how to make points of differences between the two sides. That is definitely essential. And to ensure that when you're filing your statement of claim, you don't have to file your amended statement of claim, because um, it definitely reflects very poorly on the counsel who is drafting any such document. As far as arguments are concerned, you I think one of the biggest way, as in arbitration, for arguing, is that it is not your typical court setup. It is a little informal in that manner. So so if you feel that you don't really have to feel threatened, but you have to be very confident in terms of what you're submitting. So reading up is very important. Like sir said, technical understanding of whichever industry you are representing is extremely important. So like I did this matter for a very big coal company, and I had to basically understand every little detail of what happens in the coal industry and things like that. So yeah, I think technical understanding is very, very important of whichever industry that you are going to do an arbitration in. And never be afraid of anything. Whenever something comes, just pick it up. Don't be afraid. I think that's very important.
Okay, ma'am. Thank you so much, ma'am,
Thank you so
for
much, Dave.
answering all the queries and providing us the detailed analysis. It was indeed an honor to have you on board with us, and I would like to thank you on behalf of the entire team of Legal Desire and the ADR team for gracing the virtual conference with your presence and providing us with your time on a Sunday afternoon, ma'am. Thank
That's
you
all
so
right.
much, ma'am.
All the best to everybody, and have a brilliant week ahead. Bye.
Bye, ma'am. Thank you so much. Moving on, I would now like to take the opportunity to introduce our last guest speaker for today, Ms. Susheela Sarthi, ma'am. Ma'am is a designated advocate presenting before the High Court of Karnataka at Bangalore. Ma'am has completed her master's in sociology and has done a postgraduate diploma in industrial relations and personnel management. Ma'am has also done a postgraduate diploma in alternative dispute resolution from ICADR. Ma'am has a professional experience of 34 years and she is a trained mediator and a master trainer from the Bangalore Mediation Center who has played a significant role in training a number of advocates, judges, and other professionals from all walks of life. Ma'am has contributed significantly to the mediation sector and she has even authored innumerable books, including two books on mediation in English titled Mediation, A Reader's Handbook, and Change Through Mediation. Ma'am has also penned a book titled Madhya Yastike Odugara Kaipadi in the Kannada language. Ma'am has also penned a psychological novel titled Amma Ni Eke Maduve Ade, which got the Kakkulo Sarojamma Prasthati. Ma'am is also a renowned columnist, and her columns are published in a leading Kannada newspaper called Vijayavani. Ma'am has also regularly appeared on the small screen and provides her insights on various social and legal issues. Ma'am even writes a blog titled Totem.law blog, which provides an aid to the trainers working in the field of mediation. Ma'am, we are extremely elated to have you on board today. And ma'am, the floor is all yours. You can begin with your insights and address the audience. Thank you, ma'am.
Thank you. Greetings to all. At the outset, I am extremely thankful to Team Legal Desire and ADR for providing this opportunity. I have chosen the topic resolution of dispute through mediation. One reason is that I'm so passionate about this mediation. Number two, I was given to understand that the viewers, majority of the viewers are students or budding advocates. I'm really envious. When we started our profession, this mediation was not there. Now the coming generation have this opportunity. I'm really feeling very thrilled to give some of my inputs into this area of mediation. I was equally happy when I heard Shri Aruneshwar Gupta sir and Madam Pallavi speak about various aspects of other alternative dispute resolution mechanisms. Sir had dealt in detail about some aspects of technical aspects of mediation also. So I thought, let me not again go into all those details, but take it in a different angle as to the practical application of mediation in the field of dispute resolution. Post-COVID, we all know the value of time, money, energy. And one aspect that we need to understand here is we need not have to consider mediation as an alternative to litigation or adjudication, but we have to consider litigation or adjudication as an alternative to mediation. Mediation is not just an alternative to litigation. It is not an alternative dispute resolution mechanism. It is an appropriate dispute resolution mechanism is what we need to consider. Why am I telling this? When we say dispute, we need to understand what exactly is dispute. Dispute is the result of violated expectations. Unmet needs give rise to disputes. What I want is not happening. What I do not want is happening. I want to enjoy my property peacefully, not happening. I do not want my neighbor to encroach upon my property. It's happening. Every day he is parking his car in the front yard of my compound and I am unable to remove my car. The question here is, why has this arisen? There are two parts of it. One is what I want is not happening. Another is what I do not want is happening. In mediation, we take care of both these aspects. Many a times, people are more disturbed not because what they want is not happening, but what they do not want to happen is happening. This is one area where we need to consider. When we say mediation, it's a process where parties to a dispute get the dispute resolved by themselves with the assistance of a neutral mediator. It's a voluntary process, it's a confidential process. Now, when we say this, there are some salient features of mediation. One of the salient features of mediation is that it brings a paradigm shift in the mindset of the parties. When I say paradigm shift, what do I mean by that? One is that it brings a paradigm shift in the mindset of the parties to shift their focus from position to interest. What is position? What I want is position. What is interest? Why I want? What I want is interest. Supposing I want spectacles. This is my position. Why do you want spectacles? I want spectacles because I'm 59-year-old. I can't see. I have short sight. So I want these spectacles. Why? In mediation, we take the parties through that area also. Why you want what you want? When we take them seriously to consider this question, many a times they say, I don't want this, madam. Supposing I say, I want spectacles because I want to look like Shabana Azmi. Then the mediator will silently ask, okay, do you mean to say that you want to look like Shabana Azmi, so you want to have this? Fair enough. Doesn't matter. But what did you say? Did you say that you want to look like Shabana Azmi, so you are so particular to have these spectacles? Then I may say, leave it aside, madam. I don't want these spectacles. Let us go to another suit schedule property, which I want. So what happens here is you take them from step to another step, that is position to interest. You make them understand what exactly they want and why they want what they want. The reasoning given by one side is taken to the other side. If the reasoning given by one side is appealable and acceptable to the other side, the matter gets resolved there. This is one aspect. The second is another paradigm shift we bring in the mindset of the parties is to shift their focus from past to future. Almost all of us are prisoners of the past, but we can't have any control over past. That's where we make them understand. We listen to their entire history. We give them so much of time and listen to them, listen to their past, threadbare we listen to them, and then make them understand, look, this is how your past had been according to you. How do you want to see your future? What can you do to see to it that you can see that future which you are expecting to see? What can the other side do for it? The same questions will be asked from the other side also. Then what they see here is they shift their focus from past to future. This is another paradigm shift we try to bring in them. The third element that we focus is many a times there's a paradigm shift in the mindset of the parties so that they shift their focus from tangible goals to intangible goals and intangible goals to tangible goals. Marriage is very important to me. I don't want to give divorce to my husband. This Mangala Sutra or Tali is very important to me. A lady may say, after few sessions, she may agree to give consent for divorce by mutual consent, provided she is given X amount of money. So from intangible to tangible goals, there is a shift here. In another case, the husband who is hell-bent upon divorce may say, there is a common interest here. Both of us are interested in the welfare of the children. So let us not look at divorce. Let us have a workable solution as to how wonderfully we can take our future forward without scratching any incidents of the past. So the husband who was ready to offer X amount of money and the wife who was prepared to take X amount of money and agree for divorce, both of them agree not to take divorce and they move towards intangible goal also. This is another aspect. When we say this mediation as an appropriate dispute resolution mechanism, we need to consider how effective it is. See, as far as litigation is concerned, we don't have control over the results. You can predict solutions, but here you are inventing solutions. That is the difference. Parties are encouraged to invent solutions. It's a party-centered process, as Mr. Aruneshwar put it on the slides. Majority of the aspects of mediation, wonderfully he placed it on record for all of you to consider. The party's right of self-determination is respected at every stage of mediation. That is one of the interesting point here. It is their dispute, it is their property, it is their issue, and it is those people who are going to take a call on what should be done, what should not be done, what is to be accepted, what is not to be accepted. Then what is the mediator doing? In majority of the situations, the mediator adopts facilitative role. In fact, if you just recollect, Mr. Aruneshwar Gupta had given you certain different types of mediations where there is evaluative mediation, there is transformative mediation also. One more step has come now. There is narrative mediation, there is facilitative mediation also. In none of these, we impose our views on the parties. We leave the parties to make their own wise choices. I'll tell you some cases where the dispute could not have been resolved by any stretch of imagination by a court decree, got resolved through mediation. I'm not against courts, but I'm telling you there are many cases, many disputes which can get resolved through mediation, which need not have to go to court at all. Courts can adjudicate, courts can spend their quality time over those matters where adjudication is absolutely necessary. In other areas where adjudication is not necessary, we need not have to go into that at all. I'll give you an example. There was a case of partnership dispute between four brothers on one side and one brother on the other side. Youngest brother was on one side, four brothers were on the other side. It was a family business matter which had ran into 3 generations. This was the 4th generation. Everything was entrusted to this younger brother who did not manage it properly, and there was a huge loss. Everyone wanted him to walk off from the partnership business, and they were prepared to give him X amount of money. Every date of hearing, he would agree for X amount, and then he will say, I don't want X, X plus something. Okay, next time he comes, no, X plus something is not enough, X plus something. So every date of hearing, he would go on increasing the amount, and these people would also agree to it. One fine day, they said nothing more. We have come from nowhere to this much. Further, we are not ready to give anything. Then, as a mediator, when the mediator asked the youngest brother, there is something that is troubling you. What, can you please let me know, what is it that is troubling you? Then he said, Madam, this is a business which has run in for the past, which has been running in for the past 4 generations. This is the 4th generation. If I today walk out of this business partnership business, it is as though I am not born to my father. Only 4 of my brothers are born to my father. And I am not born into this family at all. This is what is paining me. Money is not the factor. Look at this. Then this issue was taken. Why you want what you want? Why you do not want something to happen? Why you do not want to walk away from the partnership business? Why, what you do not want to happen? I do not want to move away from this partnership business. This is his concern. Why he gave this answer? This was not revealed. Then there was a joint session. In the joint session, again, an atmosphere was set in, because mediators will be trained in several skills. One of the skills is setting an atmosphere. An atmosphere is set in such a way wherein the youngest brother, spoke from his heart that this is his concern. The other brothers also agreed. If that is his concern, we all respect that concern. So he was included in the partnership. He was not asked to move away from the partnership business, but he was a sleeping partner. The offer which had gone up to 5 crores, he said, I'll just take a nominal sum of 50,000 rupees and then I'll be a sleeping partner with them. Supposing this matter had gone to court, what would have happened there? How much he is entitled to if he has to move away from the partnership business? Only from tangible goals point of view, the matter would have got adjudicated, but the dispute would never have come to an end. Assuming for a while, any party has won and he has got a decree in his favor, which has affirmed by the highest court of our country, apex court, even then he will not keep quiet. He will not accept that defeat. That's where we say, unless a party gets defeated himself, nobody can defeat him. In mediation, we address this. With a court litigation, the winner can have a decree of court in his hand, but nevertheless, there is always an enemy sitting next to you. Here, that enmity is brought down. They are in the same page. We make them understand one extremely wonderful factor, that in order for you to win, there is no necessity that the other person should lose always. I remember a cartoon picture where this cats and dogs were very well dressed. They were wearing the expensive clothes, expensive goggles, and there was a briefcase, everything, and they were there. And then there was a discussion between these two dogs. One of the dogs was telling the other dog, look, it is not just enough if we win, but the cats should lose too. It is not just enough if dogs win, the cats should lose too. That means there is always a tendency in litigation that I should win and you should lose. In mediation, an atmosphere is set in such a way that in order for you to win, there is no need for the other person to lose. Both of you can win together. How you can win together? Let us invent the solutions, let us invent the options instead of giving that to the hands of somebody else. This is how we look at it. Another case I'll let you know. See, for example, there was a suit for partition filed by the sister against her 2 brothers who were bachelors. One single property, one house property in a city. The sister's case is, we are only 3 children, we are Hindus, so I am entitled to 1/3 share. My father is not there, my mother is not there. This is the property, self-acquired property of my father. Yes, as far as substantive law is concerned, definitely she is entitled for 1/3 share. But will she get that 1/3 share today itself? There is also procedural law. No court can ignore that procedural law. Just because I admit that they are my brothers or they admit that I am your sister, no court can pass a decree immediately. It has to go through the whole process. What is the pleading of the other side? That also has to be considered. Now we say in this case, what happened was the brother said, we are not ready to give her any share. She has married a Christian, much against the wish of my parents and us. So she is not entitled. But in the mediation, when we asked that lady, why do you want, what do you want? She said, Madam, I am in USA. I am very well off. My husband is also very well off. I am not interested in this property at all. What pains me is just because I have married a Christian boy, my brothers have cut off their relationship with me. This is what is paining me. I don't want this property. Go to brothers. What do they say? We love our sister so much, madam. We are not at all interested in this property. Both of us are bachelors. We have not executed any will. We will die. We are suffering from some serious illness. In another 1 or 2 years, both of us will die. But please don't let this made known to the other side. That is our sister. She will be troubled too much. Our property will go to her after this property will go to her after death. Look at this. Both do not want the property, but the litigation in the court is pending in respect of social property with X. How do you handle this? Then there was a methodology adopted where this confidential information from one side was revealed to the other side by the parties themselves, and they arrived at a wonderful solution. The lady came from abroad, stayed with the brothers, took care of them, and they died instantly. That's a different issue. She withdrew the suit for partition. Look at all these things, how nicely the things happen here in mediation. The third example that I would like to give here is a matrimonial dispute between spouses where the husband had sought for divorce on the ground that the marriage is not consummated. There is no physical relationship between me and my wife. My wife never allowed me to touch her. This was his case. The wife's contention, there was wonderful physical relationship between us and the marriage is consummated. The husband doesn't want to live with me now because he is interested in some other lady. She had sought for restitution of conjugal rights. Look at these two cases. One is petition under section 13, 1A, 1A, IA, cruelty. And then the second one is restoration of conjugal rights under section 9 of the Hindu Marriage Act. How are they going to prove their stand? Whether the marriage is consummated or not consummated is the primary question there. That's all the cruelty alleged. How is he going to prove that the marriage is consummated or not consummated? It's a very difficult thing. But court may give one order or another order. That's different. And the cases will go from one building to another building. Notwithstanding a judgment by the highest court of our country, supposing the case for divorce, for petition for divorce filed by the husband gets dismissed even from the Supreme Court also, at the level of Supreme Court also. Let us go to that scenario. Will he go and start living with the wife? Will the wife have to wait till that time? Should the wife have to wait till that time? These are all some complicated questions that we need to understand. So what we look at from the court is sometimes, with great respect to the courts, I'm telling, because I'm also a practicing advocate, sometimes the orders are there on paper. But whether the answer to all the questions of our life is something for which we wanted a solution, under those circumstances, you have to go to alternative dispute resolution mechanisms only. The entire picture has to be seen in such a way that in mediation, we look at various aspects. We listen to their past, make them move from past to future in the present. In the present, they are looking at what had happened in the past. They're also made to look at what can happen in future, and for that, what they need to do and what their expectations from the other side is. These are all some elementary things that we do. There are several skills in which a mediator is seriously trained, and the training is so scientific, and the entire mediation process is a structured process. It's a structured and informed process. We are taking them through every stage where, unless emotions are addressed, reasoning will not work out. So in the first few sessions, mediator spends quality time, be it a commercial matter, be it a non-commercial matter, be it a family matter, whatever may be the subject matter. The mediator spends a quality time with the participants, with the parties, disputing parties, and then make them vent out all emotions and sees to it that the emotions get addressed so that there is a, a ground available for the reasoning to start working. Unless emotions are addressed, reasoning will not start functioning. In order to take decision, emotions cannot help. If emotions keep popping up again and again, then reasoning cannot work. So we give them a level playing field where they start using their intellect and then try to take a call on agree to something or not to agree to something. We respect their decision taking process also. Their party's right of self-determination is what we call. We respect their autonomy to take decision either way. There is a huge difference between decision making process and taking decision. All that a mediator does is he assists the parties in the decision making process. But taking decision is absolutely left to the domain of the parties only. The third parties are also involved. The parties whose presence is required to resolve the dispute between these disputing parties is also provided in mediation. Now you consider how we go. You imagine a tree where it's a tree of solutions. If I have to get the tree of solutions, each dispute is a different tree. But solution is a common fruit in all disputes. But the solutions that you get is a different fruit in from each tree. Supposing you imagine a tree where what we call it as a tree of solutions. The first one is we set an atmosphere, roots. We have to strengthen the roots. We strengthen the roots in such a way that we ask them after the emotions are addressed, is there a necessity for you to take decision here? What type of decision you want to take is up to you. But first take a decision as to whether you want to take a decision or not. I remember a case. A suit was filed by the bank against a borrower. Bank manager came, and this farmer also came. During mediation, the manager said, I'm going to waive off interest, I'm going to give this, I'm ready to accept principal. And then he reduced the principal also to some extent, and then he said, I'm going to take this. This man said, he agreed, yes, I had borrowed money, I had agreed to pay interest, I had agreed to pay penal interest, etc., etc., etc. Now they are giving wonderful offer to me. It's a wonderful offer. Are you going to accept? Yes. When are you going to give money? When God gives me money, I will give him money. Look at this. So, this is a situation where, notwithstanding the parties willing to agree to something, there cannot be a binding agreement between the parties, because in mediation, what we look at is it should be immediately executable. I heard Mrs. Pallavi Pratap referring to a situation where they find it very difficult post arbitration decree. There is difficulty in execution. Execution is very difficult. In fact, according to me, in CPC order 21 onwards itself, it's real CPC starts. It's very difficult. How do you overcome this? It is if the parties agree and commit, and if the order that is the settlement agreement that is entered into between the parties is something which can be adhered to and respected by both the parties in letter and spirit, then we have to go ahead with it. That's where in the preliminary stage of setting the atmosphere, we ask them whether you are interested in taking a decision or not on this mediation table. And then we also try to understand from the parties whether there is a need for settlement or not. If there is no need for settlement, there is no point in spending n number of hours with the parties when there is no need for settlement at all. Some parties may not like to settle at all. In one case, the wife said, yes, I am agreeable for settlement. I am agreeable for divorce by mutual consent. But today I can't give my consent. When are you going to give consent? After my daughter gets married. How old is your daughter? My daughter is 8-year-old. So only when my daughter gets married, after that I will agree to this. So is there an immediate need to take decision? She has a need to take decision or not. It is completely left to her right of self-determination. This is how we go and we set the atmosphere. Once they feel that there is a need to take a decision, then we take the mediation further forward. Before that also we would have spent a lot of quality number of hours because we want to address all the emotions and then we start this process. Once they say that there is a need to take decision, then we take it forward. Many may not express it in words, but as a mediator, we have to understand it from the richness of experience of our life and from various angles. When we look at it with our deep insight, we will get a feeling this is a case where both the parties need to take some decision in order to resolve the dispute. This is one stage. Then we go to the next stage where we identify the problems. We assist them in identifying the problems. Problems are of different types. One is a projected problem and another is an actual problem. I told you the example of the sister filing a suit for partition. What is the projected problem there? My brothers are not giving me my share in the property. What is the projected prayer there? I want 1/3 share. Is it the actual problem? No. Is it the actual prayer? No. Actual prayer is, I want my brothers to love me and our relationship should be restored. Status quo ante position I am looking at. This is what her prayer is. Now, we assist the parties in understanding what exactly is the problem and identifying the problem. The basic understanding with which we proceed in mediation is problem is that which has solution. If there is no solution, if solution could not have been found by the parties, then there are two probabilities. Number one, either it is not a problem or they could not find the solution to the problem. When we look at that, on the mediation table, when they start identifying the problem, some of the issues which they thought as a problem, they start thinking and ignoring those things as not problems at all. And only those areas which according to them are required to be addressed, only those areas are sorted out. This is, again, we use a very wonderful technique called as filtering, where parties are allowed to filter what they do not want to be resolved on the mediation table. It is their own call. They will take that. This is the second stage. And then after identifying the problem, we request them to go through the probable solutions. From both sides, we take probable solutions. We assist them in creating options. The options are created. And then we next go to a situation where we ask them to evaluate the options. This is called as evaluation of options. We evaluate the options and the consequences of the decisions that are going to be taken by them. Either there may be positive consequences or negative consequences. We will ask them to discuss fairly so that on a given day, they don't go back on their promises. I did not know the consequence of this decision. So that's one area where we assess them in the evaluation of options also. We make them pass through this WED analysis where what is vital to them, what is essential to them, what is desirable to them. From both parties, we take this list. What is vital to one? If it is appealing to the other party also and they say, yes, we have to accept that, then fair enough. What is essential is something. What is desirable? Many a times they drop on these things. So this is how, after going through all this structured process, then they find solutions. And once again, the solutions are again placed before them, and they are asked to either agree or disagree on those aspects. And this quality time is given to them to go back on their promise. Once they say, I agree to this, there is no commit. Until they sign, it is non-binding. They can say, I want one, I am agreeable for taking 1 crore rupees. Tomorrow they may say, I am not agreeable. In fact, my opponent has to give me 2 crore rupees. They can go back on their promises. We allow them to go back on their promises, back and forth. They can do it. And then they can come. But if you take the whole process in a structured manner, what happens is, if you give them lots of time for thinking, and there's a radical approach, and there's a rationale behind every decision that they are taking, then what happens is they don't go back on their promises, they commit themselves and they agree to something which they can respect in future also. These are some of the aspects. Do I have some more time? Time?
Yes, ma'am.
Do I have, how many minutes more I have? See,
You can take your time, 5 to 10 minutes more.
another 5 to 10 minutes. One aspect I wanted to request all of you to consider here is, mediation is also known as assisted negotiation. When we say it is assisted negotiation, we assist the parties in negotiation, we streamline the negotiation, and different barriers that may come during the negotiation process, we foresee those barriers, and then we address those barriers. And there may be a situation of impasse where both parties stick on to their own stance and there is no movement forward. Then we use different techniques to break the impasse and see to it that they again come back to the negotiation table and start moving forward in order to take decision. There are some situations where parties are worried more about what the other person should not get than what they should get. You are getting so much. I'm happy about it, but he should not get anything. This is what they feel. So there is something called as strategic barrier. There is a cognitive barrier also. Cognitive barrier is a situation where, assuming for a while I go to court, the court may decree my suit for 10 lakhs with interest and penal interest, etc., etc. I will get 50 lakhs on that day. In the hopes and in the chance of, in the anticipation of getting 50 lakhs on a future date, I will not agree for a settlement of 30 lakhs today. You may lose the case also for various reasons. Yes, I am ready to take that risk, but I am not agree to accept something lesser than what I may or may not get on a future date. So this is what another, we are all trained, the mediators are trained in such a way that they handle these situations, and there is reality testing, various components are there. And mediation is such a vast subject where so many psychological aspects are there. There are some disputes where the element of conflict is also there. Unless conflict is addressed, the dispute will not get resolved. So in such cases, the mediator also tries to see if the conflict can be resolved. Though conflict resolution is an entirely different subject altogether, at times for the resolution of the dispute, if a given conflict has to be addressed, then probably that will also be dealt with by the mediator. I'll just give one small example and close it here. A suit was filed for recovery of money against a borrower. The borrower agreed that I had taken money, etc., from the bank. He had to give that money. He was quite, capable of giving that money also. Why you are not, what is withholding you from giving back the money that you had borrowed from the bank when the bank is giving so much of concession? He said, Madam, I agree that I had borrowed loan. I had agreed to all this term, but the proceeds of this loan was given to my brother who was studying in MBBS, today has got 2 clinics, he is very rich, and he is not coming forward to return that money. Ideally speaking, it is that brother of mine who has to return this. Where is the conflict? Conflict is between himself and his brother. The dispute is between manager and this borrower. So we had to get the brother also. We had to do a private caucus between the two brothers. That brother said, yes, madam, I had taken. Somehow I neglected, I had not bothered to give this. Now that the situation is like this, I kindly ask the manager to give 4 installments, I will give the money. Manager agreed for 3 installments, matter got closed. So these are all the ways. So and you can do wonderful things. Innovation, creativity, everything comes to help. In addition to your expertise, legal expertise, and professional experience also. Thank you all.
Thank you so much, ma'am, for sharing your insights on how mediation could be used as a strong means for resolving disputes arising between the parties and how it is an impartial yet effective method of ADR. Ma'am, with your permission, we will now be taking a few questions from the viewers. So, could you go ahead? Okay,
Please,
ma'am.
please.
Okay, ma'am. So, ma'am, the first question is, for which disputes can mediation be deemed to be regarded as an appropriate method, and at which stage of dispute resolution should mediation be referred to?
See, all types of disputes can be referred to mediation. We can't say that a particular type of disputes alone should be referred to mediation. Any type of dispute can be referred to mediation. And the stage is also immaterial. Sometimes when the matter has gone to Supreme Court, three stages the party has won. The matter goes to Supreme Court. From Supreme Court, the matter is referred to mediation. In the appellate stage, the matter is referred to mediation. In a family court matter, during the pendency of the matrimonial case between the parties, n number of times the matter can be referred to mediation. It is not that only once the matter can be referred to mediation. Any number of times the matter can be referred to mediation. But earliest point of one view is that in matrimonial cases and in matrimonial cases, it is better at the earliest stage the matter is referred to mediation, because the other side wouldn't have filed the counter. If you file the counter, you will make counter allegations, and that will increase the animosity, is one view. Another aspect is, supposing it's a partition suit. If there are sisters and they have not disclosed that there are sisters, or if it is a specific performance suit, if I had already sold the property to somebody and third party interest is created, so it is better after the return statement is filed. So any stage it can come, appellate stage. In RSS, regular second appeals, the matters are referred to mediation. Sometimes matters are referred to mediation from arbitration also. Now, ArbMed is in now people are referring so many cases from arbitration to mediation, because ultimately arbitration is a type of adjudication by a private judge. So there also they refer the matter. Anytime it can be referred.
Okay, ma'am. Ma'am, the next question is, if both the lawyers are settlement minded, then in such case, should the parties to the dispute spend extra money and increase their cost for yet another professional and hire a mediator? Is that advisable?
See, if there is cooperative role of advocates, and I'm a person who has been canvassing for mediation advocacy to evolve to the fullest extent. If two advocates are there who are also trained in mediation advocacy, they themselves can resolve the issue without even going to the mediator also. And by any stretch of imagination, the whole cost will not be as much as the cost that they are going to incur if they are going through litigation, process of litigation. It is ultimately the party's decision. If they want to resolve the issue, supposing two cooperative lawyers are there, you can as well go under Order 23 Rule 3. Why do you want to come to mediation? Use all the skills of mediation advocacy and see to it that the matter gets settled there. You need not have to come here. You can exercise your right under Order 23 Rule 3, which is available. So mediation advocacy is something that we need to look at very seriously.
Okay, ma'am. Ma'am, next question is, isn't mediation just another form of attorney having dual representation of two parties with all the limitations that such conflict situations bring with them?
I couldn't get your point. Please
Yes,
repeat.
ma'am, I'll come again. So, ma'am, the question is, isn't mediation just another form of dispute resolution wherein one attorney has dual representation of both the parties and all the limitations of conflict situations come along with it?
I don't say. See, if I'm a mediator, I just remove my coat as an advocate. I'm not an attorney there at all. In fact, if I had noted properly, Mr. Aruneshwar Gupta was referring that you should first be a mediator, I mean a lawyer, and you should also be a good judge. You have to think from those two angles. If if I'm in the arbitration field, I look at it from that angle. But in the mediation, if you are getting trained in mediation, the first session itself is about unlearning. We'll make you unlearn all the things that had to be unlearned first. That means we don't think as a lawyer. We will be totally neutral and impartial. It is a clean slate where different things come. We we have no role to play, excepting that we are providing an atmosphere and navigating the whole process in such a way that the parties understand each other. It is for the parties. If parties they can take the role of lawyers. Sometimes the parties assume the role of judges also. Look, because of XYZ judgments, tomorrow I am going to win. What are you going to do? They will tell. We will assess them. We will provide an atmosphere in such a way that how in reality testing they will know where they stand and what are the strengths and weaknesses of each other's case. And even if they get, what are they going to get? And are the parties going to be happy with the decision? So this is where I say that when I am a mediator, I am not at all an attorney.
Okay, ma'am. Thank you so much. Ma'am, last question is, what tips would you like to provide to our viewers and young lawyers who aim to practice mediation in their careers?
I suggest that every student has to take alternative dispute resolution very seriously. Number one. Number two, try to get trained in mediation advocacy. You may not be a mediator, but assisting in negotiation is very important. Many a times parties may not be competent to negotiate on their own. It is there as a lawyer, you will be partnering with the mediator with the consent of your party to the knowledge of the opponent party also, and assisting your party to get the maximum result. That's where I say that mediation advocacy training every lawyer should have. In fact, I am requesting even the bar council members to take it very seriously so that all the advocates are given this training in mediation advocacy. Third, wherever there is an opportunity, please get trained in mediation, because all the skills that you get through mediation training, you can use it in your court annexed situations also. There also you will be very successful. But many of the techniques and strategies that we use in courts alone may not be useful here in the mediation environment. This is the other way around. So if you get trained in mediation, you will also be a successful lawyer.
Okay, ma'am. Thank you so much, ma'am, for answering all the questions and queries. It was indeed an insightful session, and it was an honor to have you with us on board today. And I would like to thank you on behalf of the entire team of Legal Desire and the Alternate Dispute Resolution team for coming before for the conference, and with your presence, providing us your time on a Sunday afternoon. Now, as we come to the end of the conference, I would like to share my heartfelt gratitude to all the panelists today for gracing the virtual conference with their presence and providing us their time. It was indeed an honor for Legal Desire to have you all on board, and I'm sure that our members of the audience have really benefited from the insights that you have provided with them. Now, I would like to finally call upon Ms. Megha Shavani to kindly deliver the vote of thanks.
A very good afternoon to one and all present here. I, Megha Shavani, Executive Assistant of Student Division of Legal Desire and a member of Alternate Dispute Resolution Department, considers it a great privilege to propose the vote of thanks to all the individuals who have been a part of this virtual conference and made it a memorable and a successful one. Today, my words are not enough to express the gratitude. On behalf of the Alternate Dispute Resolution Department of Legal Desire, I would firstly like to thank Mr. Anuj Kumar Sir for making this event possible today, despite of the current pandemic situations, thereby ensuring that the spread of knowledge is not curtailed across the globe. Next, I would like to thank sincerely the guest speakers for today who took out time from their busy schedules and graced the conference with their presence. I would like to take the opportunity to first thank Mr. Aruneshwar Gupta sir, who provided us with his great knowledge and insights in ADR and DITCH 4.0. Thank you so much, sir, for enlightening our viewers and the entire team of Legal Desire. Next, I would like to take the opportunity to thank Advocate Ms. Pallavi Pratap ma'am for providing us with the great insights on how COVID-19 has affected the future of arbitration. It was great to have you, ma'am. Next, I would like to thank Ms. Susheela Sarthi ma'am for providing us with the great insights on dispute resolution through mediation. It was an honor to have you, ma'am. I would now like to take this opportunity to thank the entire team of Legal Desire for providing us a platform to conduct this online conference. And lastly, I would like to thank the whole alternate dispute resolution team for putting up a great conference today. With this, we come to an end of the 2 days virtual conference on future of ADR and in pre and post pandemic arena.